Lordship, with regard to item number 4, Lordship, may I please the matter may be adjourned for the day, Your Lordship.
What about the other side?
I've informed him, Lordship, I've circulated the adjournment request.
Also for the appellant.
I'm for the respondents, Your Lordship.
For the respondents,
Lord.
as circulated in adjournment slip, it is stated that the appellant's counsel has no objection to the request for adjournment, re-notify on 28th November for hearing.
November. Okay.
May I please, Your Lordship. Lordship, I have a similar prayer with regard to item number 3 of the daily list, my lord.
You are for the respondent or
I am
appellant?
for the appellant, my lord. I have submitted a adjournment slip. my lord.
Appellant counsel, same order, 28th November.
Highly obliged, my lord.
My lord, I'm sorry, I'm a little late. Item number 1. This matter, my lord, your lordship has already heard it. This matter relates to releasing of water from hydroelectric project. Last time your lordship asked us to serve a copy of the government. We have served it.
Mhm.
Today, since your lordship is in the midst of water, my lord, any date convenient to you, your lordship may.
Re-notify for hearing on 23rd November,
November.
as per it.
My lord cannot be in fact 2 months. It will not take time. Your lordship has already heard. I leave it to you, Lord.
Meanwhile, they're all holidays in the meantime.
I'll leave it to you. I'll leave it to you. I'll leave it.
One request is there. Yesterday, your lordship has that APSC matter. We went and done an homework. We found a query which was put by your lordship that whether this is a gazette notification, we made an RTI
Mm.
and there was no reply from them. And director where it was
We
thinking.
have directed them to
So,
produce.
so 2-3 things regarding which your lordship just we have want to produce.
Do it.
Yes,
Good.
that's only leave, take leave. I'm taking leave of the court. My lord.
May I please, Your Lordship. My lord, tomorrow, item number 24, connected IA is not listed, my lord. I'm praying for listing the IA for tomorrow.
Tomorrow,
Connected.
there's some IA, get it listed tomorrow.
And
Give him
another-
the permission. He wants the permission to get the IA listed tomorrow.
and
do
my
that.
lord, and another retail, my lord, the next week, my lord, for obliged.
May I please, your lordship. I mentioned for listing of a matter tomorrow for withdrawal, your lordship, writ appeal.
Tomorrow, right appeal.
Highly obliged.
I am praying for listing, my lord, on writ appeal, my lord. On,
Fresh writ appeal.
yes, my lord, writ appeal.
Fresh.
Yes, my lord.
When do you want?
My lord, next week, my lord.
Next.
Obliged, my lord.
Monday,
Please,
Tuesday.
your lord. I beg-
Tuesday then, Tuesday.
Please, your lord. I beg to mention item number 15, lordship. When senior is out of station, we have taken consent of the other side.
All right, and concept for the appellant.
1-5.
That's circulated. An adjournment slip. You are for the appellant.
Yes, lord.
The other side has no objection. List of 3 weeks.
Obliged.
Daily list for orders, item 6.
May it please, Lordship, may kindly peruse the order dated 6/7/2023, my lord. By this order, we were directed to take press steps, although service were completed. Accordingly, we have taken steps, my lord, and there is a Dawazima court order, which your lordship will find dated 12th of November, 12th of September, my lord. Which
Just
is,
hold on. So you have taken press steps when?
yes, my lord, there is a Dawazima court report, my lord, dated 12th of November, my lord,
Hmm.
which is, it is duly served, my lord.
Only number 3.
All, my lord, all.
No. Delivered to addressee. All right, as per the report of Lavazima Court dated 12/9/23, comma, service has been effected on the respondents numbers 1, 2, 3, comma, 5, 1 and 5, 2. Thus, no one puts in appearance on behalf of such respondents despite service. Thus, let the appeal be listed for, writ petition be listed for hearing in due course.
Obliged.
Item number 7.
May I please, your lordship? Also, admittedly, on the date of the deed submission law, the private respondent was defaulter, and that has been also established by the instruction received from the government, lordship. Lordship,
What is the
rule-
application you have filed?
Lordship, rule is specific, lordship.
What is the application? What is your IA?
I for bringing on certain documents, lordship, but now the government has placed the records regarding the defaulter.
Default status of the
Yes, lordship.
respondent.
So,
Okay,
lordship, may kindly hear the main writ appeal, lordship.
all right. The submissions sought to be made in the IA can be considered in the writ appeal itself when the writ appeal is being taken up. Thus, let the writ appeal number 144/22 be listed for admission and final disposal on 28th,
Short date, lordship.
28th, 27th, 28th, whatever you want,
27, lordship.
27th. You are for the private respondent.
Yes, my lord.
What is your stand? Now there is no escape.
In the IM, my lord, we have filed our reply, my lord.
Government has also filed the same record.
Yes.
My lord, let it be picked for hearing. my lord.
Lordship, on Thursday, lordship, 28, lordship.
28th.
Obliged.
Can be done, my lord, 3rd of November, my
Lordship,
lord.
No question.
Yes.
No question at all.
Right.
Let us hear it today then. All right, come.
Yes, lord.
We'll hear it right now.
28th, my lord.
Lordship, today itself.
28th, then. my lord.
4 days lease of life. All right, enjoy.
Item number 8.
Service has not been effected on the respondent number 8. Thus, counsel for the petitioner to appellant to take steps for effecting service within 3 days, whereupon fresh notice issued to such respondent. Rule is made returnable in 8 weeks.
Item number 9 and 10.
May it please your lordship. Lordship, we have filed this IA for delay condonation as there is a delay of 92 days in filing the writ appeal, my lord.
Respondent number 5 has not been served.
Yes, my lord.
What is the report?
My lord,
5 and 11. 11 appearance has been put in.
Yes, lordship. I appear for respondent number 11.
Notice for R5, anyone is appearing? All right. Process issued to the respondent number 5 has not been served till date. Let steps for effecting service upon such respondent be taken again within 3 days, whereafter fresh notice be issued. Will you serve Dasti?
yes, my lord.
Dasti service is permitted. Rule is made returnable on 8 November.
That's the service.
Item number 11.
Okay, my lord, obliged.
Lordship, whatever we taken up after some time, your lordship, my file got stuck up. Your
Okay,
lordship,
fast.
take my- Lordship, this is your lordship, I am on a very sticky wicket, your lordship. So far as my case is concerned, your lordship, admittedly, your lordship, I did not possess the requisite qualification at the date of your lordship submission of application.
Then
By the interview, my only case, your lordship, lies in that on 2013, my appointments were made, your lordship. And after your lordship, 5 years delay that has been put to challenge your lordship. This
Does
is
it make-
precisely the case.
does
your
it
lordship.
make
I would
any
like to
difference?
admit, your lordship.
Palka Ojha,
Lordship, Alka
that-
Uchai, your
and
lordship.
number of other judgments of the
Judgment,
same.
your lordship, learned single judges also, your lordship, referred to judgments, your lordship, but only thing, your lordship, that is.
Wherein those candidates had served for 5 years.
Lordship,
We have got judgments wherein longer period of service is involved.
lordship. In one case, your lordship, this, the honorable apex court has said, your lordship, the reasonable time for filing and writ petition, your lordship.
There's
making
the
some-
only exception is that Kerala judicial officer's case, no other exception.
Lordship. Lordship. One
So-
judgment, your lordship, is that, your lordship, within period of 3 years, they should have come, your lordship.
There's no limitation. If
No
the appointment is
limitation as
illegal,
such, but reasonable time as has been-
appointment is illegal, it is illegal,
Lordship, that is there, your lordship.
plain and simple. So it can't be saved, it can't be saved.
Lordship, yes.
Writ appeal dismissed. Thank you.
Obliged, your lordship.
Item 12,
May I please, lordship, my lord, machinery is on legs, my lord, may be taken after some time, my lord.
Possible.
Obliged, my lord.
item number 13,
Mm. Not present for the appellant, even on the last date of listing, comma. No one was. What is the matter about?
This is my lord, grade 3 employee, my lord. He is seeking promotion to a promotion, my lord, but against an advertisement, my lord, which was published for direct recruitment, my lord. And learned single judge has held that he is not eligible, my lord, under the promotional.
Selection was not as per rules.
Yes, ma'am.
एक बार पासवर्ड कर दीजिए, नहीं आएंगे ऑन प्रोसिक्यूशन पासवर्ड.
item number 14,
May I please, your lordship? Lordship, this PL Sumoto is regarding the basic amenities on the major religious places, lordship. Lordship, on the last occasion, lordship, the government advocate assures that the affidavit will be filed, lordship.
Yes, Mr.
Remaining
Vora.
district. Lordship, till then only 15 district has been filed, lordship. Out of
What about the remaining districts?
Remaining district lordship, some district, they have no major places. And some of the district is still awaiting.
Do it quickly. Why you are
We'll do it, Lord.
languishing like this? Things are.
Yes. Let it be after vacation, Lord. We'll complete that.
Mr. Bora, praise for one more opportunity to file affidavits in relation to the remaining districts list on 11th December.
Deeply obliged.
Obliged, lordship.
item number 16 and 17,
Yes.
There was few orders passed by this court. Because your lordship recollect, this is regarding about that whether they are entitled to get 6-pay commission. They are contractual. So your lordship said, why don't you sit together with the government and find it out a way? So we requested government, number of meetings were held, and they said deliberation were done with the government side. Now, last time finance has not filed any affidavit. Now finance has filed an affidavit. But even then today, as on date, urban development department has not filed any affidavit in this case to find it out. What is the position?
Who represents UDD? It's like you are the for the finance? And what about the UDD?
From UDD also I have received instruction.
Then you have a dual responsibility.
Yes.
You have filed the affidavit?
So far as finance is concerned, lordship, I have filed.
We understand, but what is the stand of the UDD then?
UDD lordship, they have in my instruction, lordship, it stated that since ULBs are the third tier local self-government, finance establishment, a department has nothing to say. This is the endorsement given by the finance department. regarding revised benefits of 6 pay commission to contractual employees of Tinsukia Municipal Board. They are contractual employees.
Yes, yes.
Government in Department of Housing and Urban Affairs also agree with the views furnished by the financial establishment EA department in this regard.
Same status.
This one. The
Basically,
financial hardship is there. There's a financial burden is there.
Yeah,
So that's what my lord will just recollect. The order was passed by the chairman. But when it went to the director urban, they said, no, there is a problem, financial crunch is there. Please don't go ahead with the order. So there was a stay of the order of the chairperson to pay 6 pay. And the learned singles have with great respect acted on the letter of the chairperson.
Chairperson.
Now the financial, there is hardship. So otherwise there is absolutely no problem. My lord. We can.
Obviously, if you had the resources, you would pay.
Also, my lord, to help them.
What to do?
My lord,
We will admit the appeal. We will admit the appeal.
I think appeal has.
No, it has not been admitted.
Well, then in that case.
After hearing the learned counsel for the parties, affidavit on behalf of the finance department has been filed. The appeal is admitted. The ad interim stay order dated so and so is confirmed to last till disposal of the appeal. Dated 21/3/2022, passed in IAS civil number 3539/22 is confirmed to last till disposal of the appeal. There are what is the other IA? There are 2 IAs. Ms. Das,
One is for stay and one is to bring some additional facts,
okay.
which was
the-
not taken in the writ petition.
The connected writ appeal, writ petition number 3735/23 is also admitted. List both the matters for hearing in due course.
My lord has passed the order in the writ petition also.
For admitting,
They have to file their response also.
the respondents may file their response / affidavits in the meantime.
Item number 18.
Me, please, Your Lordship, my lord. No affidavit has been filed by the respondent, my lord. Although there
My
was a
lord,
typo.
I am hearing on behalf of the government, my lord. Time is required, my lord, instruction is not forthcoming.
What is the PIL about?
My lord, their villages are included
In the town.
into town committee carving out from the local panchayat, my lord.
Okay. Learned standing counsel, Mr.
DK Sharma, my lord.
DK Sharma, appearing for which department?
My lord, I am additional senior government advocate. Additional senior government.
Additional
advocate.
Senior Counsel, State of Assam, prays for and is granted further opportunity of 6 weeks to file affidavit in this matter. List after 6 weeks.
Obliged, ma'am.
Item number 19.
In this case, my lord, pleading is over, my lord. They have filed affidavit, we have also filed.
What is the
our
PIL?
research. My lord, here, my lord, relating to Potodova incident, my lord, in Nagaur district, my lord, 2 persons were killed in police custody and
Okay,
the people residing on the Patta land has been demolished their houses, my lord, in the name of inquiry.
okay.
Lordship, in this case, Lordship, a one-man inquiry committee has been constituted, Lordship. And Lordship, the report is to be filed, submitted within 15 days of the constitution, that is from 11 September.
11 September. Who is the chairperson?
Lordship, headed by Shri Avinash Purushottam Das Joshi, IS officer, Lordship. And he's the additional chief secretary.
Let the
to
report come,
government.
Mr. Sikdar.
And Lordship, we want to bring on record the report, Lordship.
Learned Counsel, MS. And so submits. Your good name, madam?
Lordship P. Barua.
P. Barua submits that a one-man inquiry committee has been constituted by the state government, which is wherein, Mr. Avinash Joshi, IAS, has been appointed the inquiry officer to conduct inquiry into the allegations set out in this PIL. The inquiry is expected to be completed within next 2 weeks. Inquiry officer has been required to complete the inquiry within 15 days. She thus prays for and is granted 2 weeks' time to place the inquiry officers, inquiry report on record. List after 2 weeks. DPW.
Item number 20.
May I please? My lord. In terms of earlier order, my lord, they are government supposed to produce record.
Lordship, as far as CDPO's
No,
report of
she just, the comment council only asked, the time to go to the records. Yes.
No, Lordship, earlier occasion, I actually submitted the original record has been misplaced, as stated by the CDPO Lordship.
Hmm.
Again, they have something has been stated. Lordship.
And how long will we wait for that?
They have stated that it is misplaced, Lordship. Photos that record has been given, Lordship.
You make your submissions on the basis of photo state if you find that the record is all right. If the true representation of the original record, then you can argue on the basis thereof. Or else you get an inquiry conducted where the original record is gone. Should we direct the deputy commissioner to get an inquiry? MS Boda submits that despite repeated directions, the CDPO concerned has not provided her the original record. In view of the facts noted above, the director of the social welfare department shall get an inquiry conducted and ensure that the original record is provided to MS Boda within next 15 days. Copy of this order shall be forwarded to the director, social welfare department, as well as the CDPO concerned forthwith. List on 20th November.
I am obliged.
Item number 21.
Is lost. My lord, in this case, my lord, the petitioner, my lord, appellant has, my lord, aggrieved by order that order in, my lord, as per page 102 lordship, paragraph 7 lordship. My lord, by this order lordship, the petition, review petition was dismissed, my lord, on the ground, my lord, that there was a delay in approaching the learned court below lordship.
Okay.
My lord,
Court below means
now
what?
paragraph learned single judge lordship. Now, paragraph 7 kindly see lordship.
What is your case? What is your case in the writ petition?
Case is from in 2008 lordship. An advertisement was issued lordship for the post of SIAB lordship, unbranded lordship. My lord, the petition was the Havildar at the constable at that point of time lordship. Personally, my lord submitted application lordship. His application was, my lord, accepted, but he was not allowed to sit in the, my lord, interview lordship. He approached this honorable court by filing writ petition. The writ petition, my lord, was, my lord, as interim measure, my lord, he was allowed to sit in the interview lordship. Thereafter, my lord, the result was declared, but his result was not declared, my lord. Thereafter, he filed a miscase lordship. The honorable court lordship directed to declare the result lordship. My lord, in the result, my lord, his claim was rejected lordship, and the candidature was rejected. His claim was rejected, saying that he was not qualified, my lord. My lord, the challenging that order lordship, the petitioner appellant filed a writ petition lordship in 2011 lordship. My lord, that writ petition was, my lord, partly allowed, saying that the petitioner appellant was, my lord, illegally deprived, my lord, by my lord, while selection preparing the select list lordship. But he was, my lord, not given any relief as the select list was not challenged, and the lowest scorer, my lord, was not met party in the case lordship. My lord, then, my lord, the petitioner filed an then, my lord, the petitioner filed, my lord, an application for review of the order, my lord, on the ground of, my lord, discovery of new facts lordship. Immediately after order of the, my lord, judgment of the learned single judge lordship, he filed an application under RTI, my lord, after 3-4 days lordship. My lord, whether any post vacant, advertised post vacant or not, my lord. That RTI application is at page 70, kindly see lordship. Page 70 lordship. My lord, judgment was on, my lord, 28/10/2000, my lord. This RTI application is at page, that is
Yes.
dated 1 November 2000, 1st of November 2021.
Yes.
The judgment was, my lord, on 28th of October 2021, lordship. After, my lord, 28, after 3 days, this application was filed, my lord. No reply was submitted, then another reply, my lord, this was duly received by the, my lord, office, lordship. Now, no reply was submitted, then another application was, that is 124 on.
The reply is at page 74.
Yes, lordship.
Yes, all right.
My lord, then, my lord, the reply was submitted, my lord, that is at page 74. My lord, may I read, lordship?
Yes, yes.
Total, my lord, operative.
10 posts are lying vacant.
Yes, lordship. My lord,
What is the case of the respondents?
My
In the
lord,
review, what happened in review?
review, my lord, say, my review at page 102, lordship. The paragraph 7. May I read, lordship? A perusal of the judgment and dated 28/10/2021 passed in WPC number so and so indicates that despite the contention raised by the petitioner having been upheld, no consequential relief was given to the petitioner on the ground of non-joinder of necessary and proper parties, which in the text of the case obtaining in.
Yes, Mr. Government Counsel, what do you say? The fact that he has been illegally deprived is admitted. There is no dispute. You had posts vacant, which was your duty to inform the court. What do you say?
We have filed our affidavit in the writ appeal, my lord.
Yes.
Wherein I hope we have stated, my lord, there is no vacancy at present, my lord.
What about this RTI reply? How have you discussed this RTI reply? Let us see your affidavit.
Right. You may kindly see paragraph 5 of my affidavit, my lord.
Yes.
That it regards the statement made in paragraph 2 the appeal answering the opponent begs to state that it is a fact that the appellant had secured sufficient marks in the written test as well as physical test, but he secured lesser marks than the minimum qualifying marks of 25 out of 50 in favor of his interview. Hence, he was not selected in the final merit list. Though the appellant qualified in the first segment, he failed in the personal interview.
What has this learned single judge said about his failure in the interview?
Right.
Was there a requirement of minimum marks?
My lord, qualifying marks, my lord, that was my lord 50, my lord 25
In the interview?
in the interview.
What has been said about this in the learned single judge? What is your case regarding this? Not even secured the minimum marks in.
Me lordship. My lord, the learned single judge, my lord said that that was illegal, my lord, that was done by gun sensing process, lordship.
Let's
That
see
has
where,
not been challenged.
what is the observation?
My lord,
Read.
my lord, in the judgment, lordship,
A judgment of the writ petition or the
judgment
writ
is the writ petition, lordship.
review? Let's see. Para,
Lordship. Impose judgment, my lord, that is at page. I'm sorry, lordship. Lordship, in paragraph 15,
yes.
there's 67 lordship. Well, it starts from 14 lordship. May I read, lordship? On basis of the advertisement dated 17.
Yes, minimum marks have been prescribed after the interview, after the
Yes,
process
sir.
started.
Yes, lordship.
Yes.
So that is.
All right, this aspect, Mr. Counsel,
My lord.
you don't stand anywhere. What about the vacancies? What have you said about the vacant posts?
Right now, as per my lord affidavit file, my lord vacancies are not available. My lord.
Where have you said so?
My lord. Page 130, my lord, in my affidavit.
Yes,
My lord, the deponent begs to state that, my lord, in the top, my lord,
there are 13,
there are 6 last part,
6, yes.
last part. The deponent begs to state that the present, there is no vacant post in the rank of sub-inspector AB in Assam Police.
What about the answer in the RTI? What is your stand about that?
That aspect, my lord, that has not been highlighted.
Yeah, all right, come out with that answer. Learned counsel, Mr. Sharma, appearing for the respondents, shall, comma, submit the pertinent affidavit of the officer in charge in reference to the RTI reply provided to the petitioner, wide letter dated petitioner's counsel, wide letter dated 18th April 22, indicating that 10 number of posts are lying vacant after the selection and appointment made in pursuance of the advertisement dated 17/12. 10 posts of SI within bracket AB. Advertisement dated 17/12/2008. Let the affidavit be filed within 7 days. Re-notify on 11th October.
Item number 22.
Petitioner is a retired judge of this court, my lord. Some TDS has been deducted as a judge of the High Court as well as a local actor. And they have filed the affidavit, they have deposited it, but that has not been considered, my lord, by the Income Tax Department. My lord, Income Tax Department should reconcile it, my lord.
Whereas Mr. KL, let Mr. KL come.
My lord.
All right, none present for the respondents. The writ petition is admitted. The head interim stay order dated 4/5/23 is confirmed to last till disposal of the writ petition. Office to proceed.
We have for respond number 5, we have already filed.
For the income tax department kar dena. Okay. Basically, the issue is with the department.
Department. We have already filed.
70.
Supplementary list, item 70.
May I please, Your Honor? Your Honor, I am appearing for the respondent on behalf of the conducting counsel, Mr. Mukesh Sharma for Indian Bank. He's just informed me that he is stuck in traffic jam, Your Honor. So, madam, may we kindly pass over for the time being, Your Honor.
Pass over.
Obliged, Your Honor.
Hello, that passover matter there is one thing. Call it out.
Passover matter 12.
Yes. Yes, please.
Some instruction are sought for, my lord, from the bank of.
What is the matter about?
My lord, regarding for the, my lord, have you seen the sale proclamation notice, my lord, of the properties, my lord? So, in the sale proclamation notice, reserve price is fixed up only 54.22 lakhs, my lord. And what is as per bank valuation, the resale value is
What is your
1.17 lakh. My lord, this is the reserve price. This is the minimum price.
But why can you fix, how can you fix the reserve price at 50% of the market value? Tell us. File the affidavit of the bank officials. When will you file?
But the auction is fixed on 21st.
Wait for the auction then. Hold the auction. You don't finalize the auction then.
And yeah, yes.
So tell us what is the rate offered, then we'll see. All right.
And this proclamation of sale was issued in the month of August. They have come on the last occasion. And second, already one essay is pending before the honorable DRT.
And one way has
That
been
is the
filed by them
competent
also.
court to decide the issue.
Already
Yes.
the matter is pending before DRT, gentlemen.
Yes.
My lord, we filed an essay challenging the possession notice. They filed an OA.
Yes.
For recovery, my lord. Both are pending before
could
that.
have-
All right, get that adjudicated. Get that adjudicated. Then why red court should interfere?
My lord, only the thing is that we are challenging that, my lord, the sale price because it is
No,
at my
whether it
cost
can be
and
done, whether it can show us any law that the red court can interfere in this. show us any judgment.
My lord, we are just, it is an arbitrarily fixed. my lord.
Gentlemen, we are asking you whether there is any scope for the red court to make an interference in this aspect.
My lord, when there is an
They may
arbitrary,
fetch a very big price in
my lord,
auction.
when there is an arbitrary exercise of the power.
Oh, give us one judgment
Yes,
that on this fixing of the reserve price, the High Court can interfere.
Lordship, I'm just giving my lord.
Yes, please.
Raman Shamtadu. My lord, 2012-11 SCC 511.
Let's see what is the law.
You know?
Yes. Is it a case of securitization?
Yes, my lord.
Yes. What has this court said?
My
Let's see.
lordship may look into para 17, 18, 19, 22 and 24.
17, 18.
My lord. They have said what is reserve price, what should be the basis of the reserve price. And you should have a nexus with the valuation of property, my lord, because the valuation has been done by the bank itself. 1.7 crores, 1.17 crores. And my lord, lordship is aware that under section rule 11, section 1310, my lord, it is my reached and cost. If it is sale at today 55 rupees, 55 lakhs, then I have to pay the balance, my lord. They'll recover it through DRT.
All right. Then counsel for the Mr. Ganguly submits
A Parvez.
A
Parvez.
Parvez appearing for the bank submits that he has not received any instructions in this matter. Pertinent instructions in this matter regarding the reserve price fixed for the auction of the property in question. And counsel for the petitioner has drawn the attention of the court to the judgment rendered by Honorable Supreme Court in the case of Ram Kishan and others versus State of Uttar Pradesh and others, reported in 2012, volume 11 SCC, page 511, and urges that the action of the bank in fixing the reserve price of the secured assets at, where is the document?
My lord, it's page 19. My lord, the valuation report, lordship will find.
Page number?
Page 90.
90.
92, lordship.
Then counsel for the petitioner pointed out that the valuation report of the secured assets as per the bank's own documents is
Page 92, lordship. My lord, realizable value 1 crore 14 lakhs.
rupees 1 crore 27 lakhs. The realizable value has been assessed as rupees 1 crore 14 lakhs 30,000, whereas the fair market value is assessed at rupees 1 crore 27 lakhs. The distressed sale value has been assessed at rupees 1 crore 7 lakhs 95,000, whereas the realization value has been assessed as rupees 1 crore 14 lakhs 30,000. This court is apprised that the reserve price has fixed in the impugned auction notice dated.
Notice dated. Huh?
Where is it?
21/8/2023, my lord.
21/8/2023.
Page 97, lordship. 54.22.
Within bracket, annexure 20 is only 54.22 lakhs, is fixed at only rupees 54.22 lakhs. Referring to the Supreme Court judgment in so and so, comma, it is contended that the action of the bank in fixing the reserve price at much below 50% of the 50% of the market value assessed by the bank itself is highly arbitrary, illegal, and unjustified. In view of the submissions made here in above, comma, the respondents' counsel is directed to file an affidavit of the concerned bank official in regards to the above submissions made by the petitioner's counsel. In the meantime, comma, the auction proceedings shall remain stayed. Re-notify on 8th November.
Obliged, lordship.
Typing attempt 13.
Matter is called out in the second note. On the previous date of hearing also, no one appears for the appellant. On the previous date of hearing also, no one was present on behalf of the appellant to argue the matter. Hence, the writ appeal is dismissed for want of prosecution.
Pass over meter 70.
May please. Because in this case, I'm not challenging the legality of the bank's action. We are not on the issue of the merits at all, my lord. But both the petitioners are admittedly, my lord, cancer patients. They are senior citizens, my lord. And my lord's lordships will find, beginning at page 12, my lord, this court had previously, my lord, interfered in the surface eye proceeding. The operative part of the order is from page 13 onwards. And this court had made it very clear, my lord, that the only issue was that it was making this interference on humanitarian grounds. My lord. This court had interfered on the humanitarian aspect of the matter. What had happened there, that there was an OTS sanctioned by the bank and agreed to between the parties for 56 lakhs. My lord, we paid 36 lakhs 10,000. So roughly let us say 20 lakhs. My lord. Now the OTS has expired, my lord, in the month of December. My lord, this is a residential property. We are only having our daughter with us. Both of us are cancer patients. My lord. Both the petitioners are. My lord, we are prepared to pay the balance amount, along with whatever interest on the balance amount on the original OTS amount from the date of failure of the OTS till date, my lords. And we are ready to pay 10 lakhs today itself. I'm instructed to say that.
What do you say?
Subject to that, my lords.
Your lordship, that after expiry of the OTS, there is a dues of rupees 1.9 lakhs.
1 crore.
Yes, your lordship, because bank has taken
The original.
a heavy discount at that time, your lordship.
Okay.
Taking into consideration all aspects, even honorable High Court orders.
Yes.
And taking into illness of the petitioners and all.
Lords, the statement of account at page 51 doesn't reflect that amount, but I am not
Contained with the interest. Afterward interest, your lordship.
Interest is the major portion. No principal almost, my lordships will find from page 51 also, my lord, the outstanding.
Residential property, gentlemen, you have to have some kind of human aspect also. Both are cancer patients, admittedly. Then you accept the 10 lakh rupees and then file your response.
Yes, 10 lakhs will deposit today.
Then counsel, Mr. Ganguly submits that both the petitioners are cancer patients. They had been given indulgence by this court to repay the outstanding dues towards the loan account under the OTS scheme, OTS settlement.
Yes.
Entered into with the bank. However, after making a payment of around rupees 36 lakhs from the total outstanding of rupees 56 lakhs under the OTS scheme, the appellants were prevented from making the remaining payments from the month of December onwards, December 2022 onwards, owing to their illness and other circumstances, unavoidable circumstances. He urges that the appellants are even as on date, ready and willing to clear off the dues of the bank with interest on the amount which remain unpaid under the OTS. He submits that as the secured assets is the only residential property of the petitioner, in case the same are auctioned, the petitioners would be forced on the roads in severely ill condition. In view of the peculiar, he further submits that the petitioners are ready and willing to pay a sum of 10 lakhs to the bank today itself, and are ready to engage in a conciliation proceedings with the bank for the remaining payment. In view of the peculiar facts noted above, and taking a humanitarian view of the matter, we hereby direct that the petitioners shall deposit a sum of rupees 10 lakhs with the respondent bank as offered by Mr. Ganguly during the course of submissions. First of the sale notice dated so and so,
38 minutes.
dated so and so shall remain in abeyance. In the meantime, the petitioners may approach sales/e-auction notice, approach the bank officials who shall, make an endeavor to enter into an amicable settlement with the petitioners, looking to their grave medical condition.
Your lordship, that total outstanding has been mentioned as 56 lakhs, whereas this amount is an OTS amount.
OTS, total outstanding under the OTS management. Under the OTS.
Lordships have disposed or?
No, we'll keep it pending. Let the respondents council is given liberty to file an affidavit on behalf of the respondents bank within a period of 4 weeks, less thereafter.
Item number 23 to 69.
Lordship, if Lordship,
Yes.
I
Yes.
would seek Lordship's permission if I can just mention and make 1 or 2 requests subject to Lordship's indulgence.
Please go ahead, go ahead.
Lordship,
Yes.
first, today I'm in some personal difficulty. I may need to take my father to the doctor. My colleague is there, he's taking this. So I'm sorry, I may not be able to attend. If things are okay, I may come back also. So please excuse me.
Okay, so
2 things.
Please
more,
proceed.
Lordship. Thank you. I'm so
Yes,
obliged,
yes.
Lordship. 2 more things,
Yes.
Lordship. There are specifically
Mhm.
2 or 3 things flowing in the last 2 arguments of the learned seniors.
Mhm.
One is related
Yes.
to what Lordship had said about the Gazette notifications, etc., and we need to get those records. The second was in what Mr. Das has yesterday submitted, a lot of factual things related to the investigation. Both of them, last night, I've spoken to the concerned. It may take Lordship, as I've been told, a day or 2 for getting those details. So subject to Lordship's indulgence, I was requesting, we will continue Lordship noting, but if I can get a gap of a day or so between making my arguments, because I'll make
what Ms. Kohli, let us conclude the submissions of Mr. Das and Mr. Mishra today, and then we'll fix it on the next Tuesday for your reply.
So in fact, I was going to pray for Lordships. If Lordship says if we will keep it on Monday, I would come Monday, Tuesday, stay and physically like to argue it. I was going to make
So
that.
we'll keep it on Tuesday. Tuesday is okay?
If Lordship, yes, I want to come Lordship on Monday, but if Tuesday is better, I will follow whatever is convenient to
Tuesday will be better because Monday is a miscellaneous day. We may have more matters, but Tuesday would be fine.
I am so grateful.
Then you can plan to stay for a day or 2.
Yes,
till the
Lord.
submissions are-
It has
can
to be.
concluded.
I'm so.
Okay. Mr. Mishra, how long?
No, in fact, I had concluded yesterday, but I just want to praise Lordship recall. I submitted.
I'm taking Lordship's leave with permission.
Sure, Mr. Kohli, please go ahead and all the best to your father. We pray that he gets well soon. Yes.
I submitted my lord from my written argument that accused number 69, 70 and 71, who were
Yes.
similarly situated, they are also provisional.
Mm.
They were also charge sheeted, but they are continuing in service.
So you can give a
Yes.
brief note about that.
I will give my lord, I'll give up what I have submitted, but your lordship, my lord, yesterday asked where you have pleaded. So I just want to show that.
You have pleaded that.
Yes, yes.
All right. So we accept what you say, Mr.
No, my lord, there, I'm saying because
Yes.
this, yes, but I made a goof up.
Okay.
I made a goof up yesterday, and my lord, your lordship will not believe I don't make it that, but I have a very disturbed sleep. I must tell my
It
lord,
happens, Mr. Mishra.
I read, my lord, an affidavit, a portion of affidavit from the mobile that my lord junior gave without seeing it. And there, my lord, I refer to one accused number 8, Syed Musarraf Hussain. He is, my lord, in fact, an employee of the Public Service Commission.
Okay.
Because when your lordship asked me, I said no, but then I checked up. And then, of course, I found that this mistake, I should have been careful.
It's okay.
But so far as these 69, 70 and 71 are concerned, my lord, they are not only continuing service, of course, they are under suspension, but they are facing departmental proceeding.
DP also.
And
trial, they are approvers.
Trial, they are approval. And they have not been.
So that is a bargain between the state and those approvers, that you give evidence and we retain you in service.
That's the double standard, because in our case, he said it's colossal, this thing, that thing, and we cannot keep them in service. Different, so it's a different stand that they are taking, and that's what I have
So
stated.
Mr. Kohli will have to respond to
In
that.
the reply, in paragraph 18, I will give a note of my affidavit in
In
reply.
which file?
My lord, I have item number 25, Pallavi Sharma.
Who else is there, Ms. Das? Other than you, is there anyone, any other council who will be addressing the court?
There are so many councils, my lord.
So we need to have them today.
I was told that when before the learned singers, I have seen the name, there are number of councils appearing in this case.
What are we supposed to issue invitations?
No, not.
Yes.
My lord, page 157.
157, just.
It's a affidavit in reply starts from 146.
Just. Yes, please.
Affidavit in reply is filed, my lord, on 23/10/2019. My lord will get at 146.
This was in writ petition.
This was in a writ proceeding, my lord, a writ petition 2163 of 2019.
Just one. Writ petition 2163
of
of 2019. All right. Yes.
33,000. And the present appeal is 98 of 2020. 733. Yes. Item number kitna hai wo dekh lo.
Yes.
My lord, relevant, your lordship will get paragraph 18 at page 157.
Yes, para 18.
Para 18 at 157. I'll start from the second paragraph at 150. Paragraph 18 at 157.
Yes, please.
My lord got it. Your lordship. It is further stated that none of the accused persons obtain anticipatory bail, and it is well within the knowledge of the police. Further, only 3 persons, so and so accused number 69, so and so accused number 70, with so and so accused number 71, who became approver even before their arrest, applied for anticipatory bail, which was not opposed by the police, and secured orders for anticipatory bail. These 3 approvers who have been charge sheeted, wide supplementary charge sheet number 8, on record, my lord, I have brought in compilation.
They have been granted pardon already?
Yes.
Pardon already granted? Pardon already granted by the
Pardon
court?
was already granted.
Okay.
Wide supplementary charge sheet number 8 dated 2/1/2019 are still continuing in service, which exposes the double standard of the state of Assam, and also do not rule out the possibility of connivance between the state and these 3 approvers, who appears to have been made approver by promising that they will not only get immunity from prosecution, but their service shall also be protected.
Yes.
I further state that a statement made in paragraph under reply to the effect that to the extent of fraud is unraveling every day is false, concocted, and imaginary as stated above. Then these are, of course, normal denial. But what I wanted to show is that these 3 persons, this is one, and of course, goof up, your lordship, I apologize for that. And one more thing which I would like to point out, my lord, which my learned friend pointed out. Because I will show their reply. Their gazette notification, they are keeping quiet, silent.
They are keeping silent.
Silent.
Okay.
That your lordship will see item 62. Item 62. This is writ appeal 333. Mr. Das had referred this.
Gazette notification of that order whereby the probationary services were perpetually continued.
That's right.
What is the date of the order?
My lord, date of the order is 20th 1. I'll just give my lord.
Which order?
It is 20th January
The one regarding which you are raising an objection, Gazette.
28th January 2018, at page 91, if I'm not wrong.
That you have different page number is there. No?
Yes, all right.
In mine, it was 7.
We'll just take note of the date.
My lord. So your lordship will kindly.
The pleading regarding the
Yes.
same not having been. Yes.
My lord. My lord, your lordship will kindly come to page 47 of the writ appeal. The writ
Triple
pet-
three.
yeah, writ petition starts from page number 35 of WA triple three.
You are referring to page number
Page number, my lord,
47.
47, and the writ petition starts at page 35. Annexure
All
A.
right. This is the part of pleadings of the
Yes, yes.
writ petition.
Yes.
Okay. Yes.
Now, if my lord will come to 47, paragraph 14, that the state respondent in later part of July 2019 have filed affidavit in opposition in the aforesaid writ petitions. Upon perusal of the said affidavits, the petitioners were surprised to notice a notification annexed to the counter affidavit, wherefrom it is discernible that period of probation of the petitioners have been extended by 2 years or till completion of the investigation, whichever is earlier. In respect of petitioner number 1 to 7, the authorities have purportedly extended their probation period by notification dated 21/2018. This is the notification in question. Further, in respect of petitioner number 8, another notification has been issued bearing so and so have been, however, no date is discernible. In fact, there is even no space for putting any date. Nevertheless, the signatory, additional secretary to the government.
The significant fact is regarding the Gazette notification.
Yes.
Where is that pertinent submit? What have they replied to this?
My lord,
Because the pleading doesn't say that about the gazetting. And from what Mr. Kohli could just submit, he is also not very sure.
Yes.
Because he has not been given those notifications so far.
In the affidavit in reply, what the government has said, that I want to bring it to my lord notice. Page 169, my lord, annexure B, the affidavit in opposition starts from here, begins from here, and the relevant date page will be 193, my lord. Because we have also said, my lord, these are all antedated.
That
Even I've
we
said.
have read.
Yes. Now, page 193, if my lords can kindly see.
193.
193, paragraph 75. 75. The contents of para 14 and 15 of the writ petitions are denied, being incorrect, misconceived, and misleading. It is specifically denied that the extension of probation of the petitioner is an afterthought and that has been passed behind the back of the petitioner. It is respectfully submitted that the extension of the probation of the petitioner has been done strictly as per Rule 15(1) of the Assam Police Service Rules 1966. Allegation of victimization and extension of probation being an afterthought and antedate of extension of probation's orders are specifically denied, being
So
incorrect.
what you can say is that there is no assertion that there was a Gazette notification.
This is a bar denial, my lord.
Bar denial. See, already the Gazette notification is a public document. It will come out. If it has been done, it has been done. If not.
My experience, my lord, is that extraordinary gadgets they play the mischief. My lord will know better than me. But your lordship, I'm sure with your lordship experience, your lordship will definitely catch them if they try to do it. But this is what I have to submit. And of course, in reply, whatever, if your lordship permits, I will.
The assistance of a written submission, as it was there in that appeal. Otherwise, to consolidate and compile everything becomes difficult.
I will give, my lord.
Because your written
And if your
submissions in
lordship
those.
says, before I have to give, I'll give before, or after hearing, after their completion, I will give whichever your lordship.
Mr. Mishra had given us very exhaustive submissions in that criminal appeal.
I also made a note, but I am just making a note of it.
Okay.
Because it will really help the court also.
Yes, please.
My lord, yesterday I have given a note and already is given to Mr. Kohli also note.
Okay, where is that note?
But that note, what? Only for the purpose that whatever note has been given, it is based on pleadings. Something it is not in pleading, your lordship will please ignore it.
Yes, very well.
Something which is not in pleading.
Okay.
And what I have gone through it, it is with the note again, we will reconfirm. But I don't want to put something which is not in the pleading.
Additional affidavit, they were supposed to.
Now, my lord, just recapitulate, which yesterday I argued in one of.
Which file are we required to take up?
My lord, that 50, my lord, that retapel 50 and 333. This will not take much time, my lord. Just recapitulate 50 and 333. Where is my file? My file.
Yes.
Now, my lord, your lordship, when it was dealt and we said regarding about the gazette notification, then your lordship has asked Mr. Kohli to give a reply on this, whether notification is there or not. My learned friend now wants a certain time to look into it. Very well, he can look into it. But yesterday, my lord, I just forgot to show your lordship regarding one thing, my lord, about regard to this 333 of RTI which we made. Just I will show it. Of course, your lordship has expressed that if it is there, if it is there, if it is not there, not there. That's what. But what we have done also the homework, the clients.
Obviously.
Kindly see, my lord.
They've got a lot of time to spare.
Yes, my lord, this kindly.
Page number?
Department, yes.
What are you referring, Mr. Das?
Which is, I am referring page 231
of writ appeal 50.
I'm just giving for a moment, my lord. My lord, 228 in writ appeal 333.
333 then. 33.
Yes.
33 only.
This director. Kindly see 228, my lord.
228.
This is a department which prints the gazette notification, my lord, at page 228. And this was made on 3rd of October 2019. Kindly see, my lord, address to so and so with reference providing prayer for providing documents in the RTI. With reference to letter, sir, I would like to inform you that after checking the gazette receipt register of this directorate, it is found a letter number dated dispute 28th of January. This 20th of January, issued from the Home Department has not been received by this directorate. Hence, the receipt register and copy of it does not arise.
Yes.
So that's already, and they have not responded to this. This is apparent. They cannot. This is why, my lord, we are saying that this is only for the cover of that confirmation. Now this is apparent. And they brought it by an additional affidavit subsequently. We thought of making an RTI, accordingly it was made, and it is now confirmed, my lord. But nevertheless, your lordship has given time for range of justice, at least, my lord, whether it is available on record or not. That's your lordship want to see.
In the interim, what will be the status?
And your lordship also had that in the interim, what will be the status, if I remember correctly? In the interim, what will be the status?
Yes.
That's here's my lord, Mother Kohli
has to respond. He has to respond.
My lord, in addition, my lord, we said about 3 LA's approval. Still, they are yesterday. Still, they are confident. We brought it by an additional affidavit.
That was there in the affidavit in reply in one of the petitions.
No. Today we have filed additional. Yes.
Mr. Mishra just pointed out it is already there in petition number.
But as on date, no, 333. No, this is latest we got. This have got latest.
Repeat some for reply.
They are still in service. That's what you want to say.
No, my lord will kindly see. See at page 696.
696.
Yes.
Yes.
The list of officers provided below does not purport to get, it is only the APS who are in service on 1/9/2023. Now kindly see at page 701. 701 at 170. Debrobata De APS is under suspension with effect from 6/8/2019.
Just to know.
Right.
Page 701. Serial number?
701 is down below at 170.
Yes, all right.
This is the
170, yes.
He is an approver, my lord,
Hmm.
and he is under suspension
Then,
since with effect from 6/8/2019. Now, kindly see,
that makes it only one.
yes, now kindly see 713, my lord, page 713. Another approver, my lord. Kindly see 713.
Hmm.
This is 1st of August 2019, my lord.
Hmm.
Whereas Srimati Abhisheka Barua, ACS become approver. Now is case of ACS, my lord.
Hmm.
He is approver in Dibrugarh PS case and she have given her conference statement under so and so before on 3/8/2018, where she disclosed the ways and means by which she procured the job of so and so. Where is she Abhishek Barua, ACS Circle of Nazira?
Avishika Barwa.
Abhisheka under place under suspension dated 17/3/2018. Under the suspension was extended for another 3 months. So and so last, my lord. Now the governor is pleased to extend the period of suspension so and so with effect or till further orders, whichever is so and so. Now still she is in service and she is getting the substantial allowance. Now next kindly see 714. 28th of November 2019. So this is also a case of one of the approvers, Sanjan Fukan, my lord. I will not read again Sanjan Fukan.
Yeah, all right.
Yes. Until further order, there's the last year lordship kind of till further orders. Until further orders. Next is 715. This is what we said about the gradation list, my lord. Now 6th of August 2019. Now, my lord, will kindly see the second para. Whereas the governor of Assam by notification dated 7/3/2009 was pleased to grant sanction for prosecution. 7/3 and this is 6th of August 2019.
Yes.
He was placed under suspension. So he was working in between. Kindly see, my lord, this is, that's why I thought.
This is also an approver.
Yes, he's an approver. That's why I thought there may be two legs of argument. One, the police report, whether it is tainted or not. Because one paragraph of judgment, I'll show it, my lord, when I go to next league of argument of Manaspatim Haloi, my lord. I'll show that, my lord. Now, my lord, this is what is respect of, my lord, the Dilip Kalita, my lord. My lord, kindly see 718 for a moment. 718.
Cross-examination, Mr. Das.
Yes.
Sorry.
Yeah.
That is not the scope of this proceedings.
This is what
You're
my
not
lord-
going into those.
Yes.
No. Absolutely.
No, my Dilip Kalita is, my lord, so far as I
Will not.
Yes, will
consider.
your lordship, that's over in so far as APS of 333 and 50.
That is
Now, next, my lord, I'll be, well, just move to another. Where's my note now? Yes. Of Manaspatim Haloi, my lord, which is writ appeal 96 of 2022. I'll move to
इसमें रिकॉर्ड कर लीजिएगा. Mr. Das is appearing for the appellant in writ appeal number 96/22 has filed an additional affidavit to bring on record mainly the facts pertaining to 3 of the officers who were selected in the extent recruitment process and are continuing its service despite having been charge sheeted. Copy of the affidavit. The copy of the cross-examination, copy of the statement of one of these 3 officers, namely Abhisheka Barua, recorded during trial of special case number 2/2017 has also been annexed with the affidavit. However, we are not inclined to take the said cross-examination on record as it pertains to an ongoing criminal trial. The other documents filed along with the affidavit are taken on record. Mr. So-and-so Kohli, representing the respondents, may respond to this additional affidavit to the extent indicated above by the next date of listing. The Raja ka hearing continues. Yes.
Now my lord will take up writ appeal 96 of 2022. It is taxation. He belonged to taxation department, man. Taxation department. Now, so far as the principle of natural justice, I think my learned senior friend has extensively argued on principle of natural justice. Now, the police report, it is also, my lord, your lordships, we accept it on the basis of police report, it can be discharged. But what is that police report? Or the police report, whether now there are two, the argument which I have seen, my lord, that argument is when it is a colossal fraud as a whole is a fraud, then my lord, either your option was to terminate whole. If you, what I have understood that if you have picked up 60 candidates, a notice was required. That I will just adopt also. That's I think that's the law and which is been in the judgment of this apex court also. Now I will try now to convince your lordship. Very important, my lord. I'll try restrict my argument on the police report. My lord, it is your lordship because on that basis it was discharged. All the materials was placed before the in-house committee, my lord. Who has got? To what extent they have gone it? Because ultimately, my lord, on the last day, I'll show, my lord, when the argument was concluded, the office file was placed before the learned single judge. Office file in seal cover. So where we were not privy to that, my lord. Now, my lord will now starting with it, my lord, Manas Patam Haloi. I just want to draw your lordship attention to one paragraph only of a judgment of Inderpreet Singh Kahlan, my lord. One paragraph only. That paragraph, your lordship, 41. That is 2006 11 SCC 356.
Yes.
Yes. Only paragraph 41, my lord.
We have got the judgments. Mr. Mishra has given everything.
Yes. Just I will read one paragraph.
Yeah.
One paragraph only I will read, my lord.
Yes, please.
If the services, paragraph 41. If the services of your lordship got it, my lord, paragraph 41.
Yes.
If the services of the appointees who had put in few years of service were terminated, compliance with three principles at the hands of the state was imperative. One, to establish satisfaction in regard to sufficiency of the materials collected so as to enable the state to arrive at its satisfaction that the selection process was tainted. Number two, to determine the question that the illegalities committed go to the root of the matter, which vitiate the entire selection process. Such satisfaction is also the sufficiency of materials were required to be gathered by reasons of a, now this is, my lord, is very important, gathered by reasons of a thorough investigation in a fair and transparent manner. So now, my lord, my lord, it reveals that investigation has to be thorough and it has to be fair and transparent manner. So whether in the particular case, my lord, whether there was a thorough investigation carried out, whether it was fair and transparent. One of the few examples, my lord, you have lordship has seen. There are others also where we will say that it is not carried out any fairly or transparently, it has not been carried out. But prima facie, I am not saying that your lordship will make a roving inquiry of it. No, because ultimately our discharge is based on that only. Unless I have to satisfy, they have the in-house committee has not done any homework. Prima facie, I have to show it, my lord, before your lordship. Without controverting. No, without controverting whatever is on record, without controverting whatever is record. What type of investigation they have carried? My lord, only 60 candidates which were identified by that officer, my lord, it was placed before the government. Normally, what the government exercise should have been done, all those candidates.
Entire records.
Entire records. Which I will honestly, I'm saying it was a doubt that entire records was placed because it is revealed that only 60 candidates. How you segregated, tainted and non-tainted? And these are all continued.
One question.
And one? Yes. Yeah.
When were those 3 candidates
Yes.
who are still in service granted pardon? What is the date?
It's,
Mr. Mishra might be knowing it.
yes.
No, I get the date, my lord. I was only told you have written that.
Date he is to.
In the,
Lately in 2022.
in my written submission, I have written they have not only been granted pardon, but they were kept. But date
The relevant fact is
Very, very important.
that if they have been granted pardon subsequently, then how they were segregated at the stage when these officers were
I'll get
sent home. That is what.
I'll get the order. I'll press it before.
No, date, she is asking the date. My learned friend is there, your lordship is asking the date, particular date.
We'll get the order.
We'll get it, my lord. Yeah. Yes. Now, my lord, how they have done? That's why I thought that I should place it before God, because on record, it was before the government. All it was, my lord, all FSL, all whatever, all it was there. How they, I will demonstrate. I will not contribute anything on the face of the records. Now, my lord, that's why I showed the judgment. It should be fair, thorough and transparent investigation. Then only you can rely this, the police report which was submitted. Now, this is one judgment, my lord. I will connect with those, my lord, affidavits and pleadings which I have brought before the learned single judge, my lord. Now, second judgment, I'll just complete this 3, my lord, then I will connect. Only one paragraph I'll show it. I will not read.
Please.
My lord, next Krishna Yadav, 1994, 4 SCC 165, paragraph 15. Now, this is very important, my lord. Krishna Yadav judgment.
The written submission was just compiled. And that's
Paragraph 15.
yes.
Yeah, because I don't want to trouble with the facts, the background of this case. It has been said by my all previous colleagues so far as facts. What is important in the paragraph and how I want to connect with my case only, that's how I want to show it, my lord. Paragraph 15 kindly be seen, my lord.
Yes, please.
Yes. I'll take your lordship to read this paragraph, small paragraph. It is not possible for this court to enter into factual domain and decide the case one way or other. We have already mentioned about the recording the report of CBI. We will go only by that as the report commends itself to acceptance. In our considered opinion, the CBI has done a commendable job and has not failed to call a spade without shielding. Lordship will kindly mark this. Without shielding anyone concerned, including a minister, we will extract the following from the report, setting out our conclusion at the end of each section. I will not trouble this all. When you do a fair investigation, you don't spare anyone from minister to peon. It's a commendable job you have done it. But can we say it commands an acceptance in our case? Material was looked into in this case. So my lord, in this case, material was looked into by the deep court. This is what I want to. I will connect the my lord, my pleading and this. Another, my lord, judgment is 3 is my lord, O Chakradhar, my lord. One paragraph I'll just read, paragraph 12. O Chakradhar. That they have relied upon. Government. Para 12. Lordship got it, my lord. Para 12.
Yes, please.
Now, para 12, as per the report of the CBI, the whole selection smacks of malafide and arbitrariness. All norms are said to have been violated with impunity at each stage, right from the stage of entertaining application, with answers it while in the custody of chairman, in holding typing test, in interview, and in the end while preparing the final list. In such circumstances, it may not be possible to pick out or choose a few percent in respect of whom alone the selection could be cancelled and the services in pursuance thereof could be terminated. The illegality and irregularity are so intermixed with the whole process of selection that it becomes impossible to sort out the right from the wrong or vice versa. The result of such selection cannot be relied or acted upon. It is not a case where a question of misconduct on the part of candidate is to be gone into, but a case where those who conducted the selection rendered it wholly unacceptable. Guilt of those who have been selected in not the question under consideration, but the question is, could such selection be acted upon the matter of public employment? We are therefore of the view that is not one of those cases where it may not have been possible to issue an individual notice of misconduct to each selectee and seek his explanation in regard to large-scale widespread and all pervasive illegality and irregularities committed by those who conducted the selection, which may of course be for the benefit of those who have been selected, but there may be few who have deserved selection otherwise. But it is difficult to separate the cases of some of the candidates from rest, even if there may be some decision influence to apply to the facts of the present case. Now, I have seen, my lord, the judgment has been relied also by latest judgment of the Apex Court in 2021 by the Honorable Speakers of India. That is the judgments on latest judgment. 2021, my lord. These all the judgments. We will not cite it now, my lord. Just your lordship will note down 2021 4 SCC page 631.
Okay.
We will give a reply to this, my lord. All the judgment was taken into consideration by the Apex Court, latest judgment 2020. Now, yes, now my lord will try. Now I will try 3 judgments I have shown. I will connect what the learned single judge has said in page 587. Para 48, my lord, para 48 of the judgment. Kindly say para 48.
Okay. What to do is take out a separate print of this judgment, of the SB judgment. Take out a separate print. It will become easier. Yes, please.
So what I will try to do
Para 48.
after end of the day, whatever in sequence ways we will place it, so it becomes convenient for the court. After the judge, all is concluded. Para 48. Para 48. The Dibrugarh police report following investigation are part of records. My lord will kindly note down. The Dibrugarh police reports following investigation are part of records, and compilation of the same has also been furnished before this court. Because my learned senior friends has given a compilation of the entire.
But by that time, charge sheet had already been filed.
Yes.
Okay.
Charge sheet is there.
Charge sheet was filed by that time.
Yes.
Their charge sheet will not, your lordship will get the.
No, what we are asking you is whether the charge sheet was filed by the date of the impugned orders or when the dates came to be considered.
No, it was filed when, in fact, those orders were challenged in the writ, the discharge order.
No, what we are asking you is whether the 173 report was filed before these appellants were discharged.
Yes, in fact, but if your lordship remember, it should, your lordship, one of the affidavit wherein the respondent number 2 and 4 said that Dibrugarh, SP Dibrugarh gave a report. And therefore, I said that only this report was there.
So that's what we are asking you. Whether the charge sheets were considered.
Charge sheet filed, my lord, in one charge sheet was filed, the original on 24/1/2017.
My lord,
17. All right.
My lord, will kindly see. I have given a note whether charge sheet has been filed. Page 32, kindly see. Page 32 of this paper, page 32.
Because what was going on in our mind was that interim police reports were submitted rather than those progress report kind of thing.
My lord, kindly see page 32. Page 32. These are the dates. These are the dates. The date, the number of candidates on 28/7/2000.
No, but the main charge sheet was filed earlier, no?
Yes, yes.
Okay.
And on complete on 26/8/2000, the 11 number of 10 was submitted. We have been told the 11 number of charge sheet is okay. After the judgment was delivered, then 11 number was 11 number. But it was there, my lord. So, my lord, entire records was placed before the learned secretary in a seal cover. Now, I just continue with your lordship permission.
Yes, please carry on.
Para 48. The Dibrugarh police report following investigation part of records and a compilation of the same as was furnished before disclosed by DK Mishra learned during the course of hearing. It is seen illegalities and irregularities discovered in the selection have been scrutinized and investigated upon in respect of each of the restrictions. Detailed police investigation enabled to pick out the candidates who had unlawfully benefited. A mere perusal of the police report leaves no room for doubt as to the thoroughness with the investigation was carried out. Irregularities attributed against each of the petitioner are minuted, reinforced by statement made before the investigating officer by such petitioner as available in the records, admitting to their complicity. Having gone through the police report, the prima facie view of this court is the same comments itself to acceptance. Because two judgments which that's why I referred my. Now the question is, could such selection in respect of petitioner be acted upon in a matter of public employment? Also, whether the state respondent could have acted upon the police report to eventually discharge the petitioner from service. No law is cited on behalf of the petitioner support a view that there is a legal embargo in acting upon police report as should be done in the present case. Now, this is what I will not trouble this because these are judgment which relied on Krishna Yadam Chakradhar. Because there was thorough investigation, fair, thorough. So it commands acceptance. Here also learned single judge, all are before me. It commands it. You have segregated, you found this. So this is what I just want to point out that there is no thorough, fair investigation.
Now, how do you say that when charge sheet has been filed?
Yes. Now,
how do you say that it is not thorough?
Then I will say this is what I want to satisfy your lordship. Why this investigation is not thorough or why it is not better. If charge sheet even it was fine. I'll demonstrate that, my. Yes. My lord, your lordship will kindly see page 267 of the paper. Only your lordship I will just put in my way. Your lordship can just ask me. But in the meantime, I just mental framework, which I'll try to satisfy. My lord, your lordship will kindly now see page 267 of the paper.
Yes. $267.
Now, this affidavit, there is an additional second affidavit filed by the government at page 250. 250, which is starts. Now, page 267 kindly be seen, my lord, at para 44. Because while deciding, these persuade the learned single judge, a convincing one because of this additional second affidavit which was filed before the learned single judge, my lord. Page 267, para 44. Pursuant to the investigation being carried out, so far as 10 charge sheets, the initial charge sheet and 9 supplementary charge sheets have been filed before the concerned criminal court. Some of these said charge sheets demonstrating the role of the accused person whose role has been unheard during the detailed and comprehensive investigation being carried out by the Assam police are also being submitted in a seal cover for consideration. This is what I am saying that It was last day, it was submitted with the seal cover.
So the sealed cover is irrelevant for the reason that copies of the charge sheet were supplied to the accused. So it makes no difference.
So, but this, what I'm showing before the court, that what they have done on the last day.
We understand, but the fact remains that charge sheets have been provided to the accused under 207. So what is so very secret about them?
But no, 207, certain documents when the accused, my learned friend was there, then only the charge sheet was given. No other documents were given. Documents were later on by law.
No, we obtained certified
December.
copy. We obtained certified copy
Yes.
of the charge sheet, which was filed. We obtained certified copy.
No, only charge, just,
No,
that's
ARPP was not compiled with like that. So we
But
obtained certified.
207, we got it later on, that's why we brought it. That's why I'm saying, man.
That fact is pleaded on record, that the documents were supplied subsequently.
Yes.
Is it a part of
Yes,
record?
yes, yes.
Let's see. Yes.
Now, my lord, I'll just finish this, my lord. I'll just note down what your lordship has asked, my lord. This 44, now, my lord, this 44, we have given a reply of 44. Now 43 of the judgment we kindly see in respect to this 44, my lord, how the learned singular judgment at page
Mr. Das,
583.
Mr. Das, before that, please read para 46.
46.
How you explain that?
In the third supplementary charge sheet dated 19/4/2018, filed by the Assam Police, wherein the petitioner herein has been read, accused number 39 or A39. A copy whereas been filed along with the present and the role of the petitioner has been found as under. During the course of investigation, Manaspatim Haloi A39, Superintendent Morigaon was arrested on 22/2018 based on below noted evidence. During evidence, the answer script of Manaspatim Haloi bearing book number so and so was recovered at the house of Rakesh Kumar Pal, located at so and so, Bhagar under so and so. Total marks of the answer booklet of General English bearing of the arrested accused Matam was 141, which was seized so and so in tabulation sheet of APC. The mark is enhanced to 191. Enable the arrested accused Matam to security job. I have got an answer. I know your lordship will ask this. So I prepared on this, my lord. On this, what is the answer to it, my lord? Then I'll just give a quick answer to this. Like let us do. Yes, this allegation. Yes. Now, my lord will kindly see, at the time of 207, we got this document, 207. So kindly see.
So this is your pleading from which they are referring. Copy whereof has been filed by the petitioner along with the presented petitioner, supplementary charge sheet.
Yes.
So this is a conclusion in the supplementary charge sheet.
Kindly see the.
Yes.
So kindly see at 6, my lord. 6. Examination of toner of the printed methods of standard booklet mark PS1 to PS9. This is a sample, my lord. Sample of so and so. Examine answer script bearing number 1300611. This is my book number, my lord. 13 so and so. Under so and so. Under is the element composition system reveals similar spectrum indicating that chemical vis-a-vis quality of toner was similar. So my answer scheme was never a fake.
Never it was a fake. And when they done spectra test, my lord, detail is there, which is given to me.
Para 9.
Para 9. Para 9 of this case.
The invigilator's signatures did not match.
Person who wrote para 9, my lord.
Hmm.
Yes, the person who wrote the blue enclosed signature stamped as marked as 158 to 1 did not write the red enclosure signature. Similarly situated.
This is in relation to the allegation.
This is what I have been told. This is not in respect of mine.
There are further same observations. There are 10,
Yes.
11, 12,
No, there are
13. So the finding is that the invigilator's signatures on your marks, on your answer script, based whereupon the marks were given, did not match with the actual invigilator's
No,
signature.
this is not the allegation, my lord.
That is the
That
allegation in the
my lord.
injunction. All right.
Not in respect of mine, my lord. Not in respect of mine. My lord,
Right now, forget about everything else, Mr. Das. 141 to 191. How do you explain?
Yes. So we will come to that, my lord. I will explain, my lord. Just give me this so that I collect. I just noted down about.
This is a part of it. The affidavit which you read,
No, I know, my lord.
we are referring it from that affidavit.
No, I just complete. I will just go through I'll give a reply, my lord.
Sure.
My lord, now, can you see para 43 of the judgment? 43. That is page 583.
Yes. Hmm.
583. 43 kindly be seen.
Hmm.
Now, just want to point at page 583, my lord, from 1, 2, 3, 4, 5, 6, 7, 8 line. Yes. Now, my lord, the ground of arrest and the materials collected against the petitioner contained in the aforesaid office files.
Hmm.
Now, my lord, we see the 9 pages tabulation sheet.
Come to the
Yes.
bottom 5 lines of this para.
Yes. That's right.
It is revealed
Yes.
that the answer scripts were not printed in the comment process.
Yes.
For the moment, ignore this.
Yes.
The next lines. The signatures of invigilators in the answer script were found to be fake and mismatched with the invigilators who are on duty on the respective day of examination in the particular examination hall.
No, in my particular, there is no specific allegation. This is almost decided, while we decided. What I say, overall, I am showing it before your lordship. Your lordship will what they have done, what type of investigation they have carried out, my. Now, my lord will kindly now. Majority of the documents, my lord, was only under 207 we got after the judgment was passed. Those 9 pages tabulation sheets that we got it only after the judgment when 207 when we appeared before the learned trial. Then we got this and my lord, we pleaded this in para 38, can you see? Para 38, page 27 and 28 of the appeal. This all has been pleaded. At page 27, my lord. That your lordship will get a view what we pleaded. My lord, at page 27, para 37. 37, 37. 38. 38A, my lord. It is submitted. Lordship got it, my lord. It is submitted. Some of the documents referred in this appeal were not available within the appeal and at the time of hearing before the learned single judge. In fact, the said document was supplied to the appellant by the learned trial court subsequently after disposal of the read petition being the subject matter of the appeal. be 9 pages of tabulations. Now, my lord will kindly see at para, yes, we have given. Now, my lord. Now, my lord, in response to para 44 of the affidavit in opposition, what reply we have given, which I have shown, my lord, before your lordship. In the writ petition, it is page 314 of that 44. 314 at para 39.
Yes.
At para 39. Lordship got it, my lord. With reference to a statement contained in para 44 of the said additional affidavit.
Come on, straight refer to what the discrepancy in the marks. What have you said about that?
My lord, just I will read this and I will just, your lordship, just give me an opportunity to read this, my lord.
Oh, you read at your own
The
convenience.
petitioner states and submits that the entire investigation instant case is faulty, motivated and tainted with a blemish of malice, and therefore the consequent charge sheet filed in the criminal case are baseless, faulty, motivated, tainted, blemish of malice. The petitioner stated and submitted during the year 2013-14, 2014-15, a total number of 421 candidates who successful in the APS examination. Dibrugarh police took more than 35 months to carry out the whole investigation and submitted charge sheet and 10 other supplementary charge sheet. A total number of 74% have been named as an accused in the entire case. Out of the said 74 accused persons, 60% are the candidates who were successful in the APS examination held in 2013-14 and 2014 and 15 and subsequently were appointed under various departments of the government of Assam. Therefore, it is a positive case made out by Dibrugarh police that 361 candidates who also stood successful in the said respective examination have been legally appointed during the tenure of Rakesh Kumar Pal, while he was the chairman of APS. Therefore, are deemed to be untainted candidates. Out of these said 361 untainted candidates, there are instances where several candidates have been deliberately left out by the Dibrugarh police to investigate for oblique reasons. The police authority have investigated only selective candidates in a motivated and malafide manner. In fact, from the records of the case, it is apparent that several candidates whose name had surfaced during the investigation against whom there were incriminating evidence were not investigated and they continue to remain in service. The Assam police for oblique reason have chosen not to investigate such person. Therefore, it is amply clear investigation carried out by Dibrugarh police is a faulty investigation based on conjectures and surprises, and no reliance can be placed upon the various report and or charge sheet filed by the said Dibrugarh police to discharge the petitioner from service by the state respondent. The petitioner craved leave to refer the records of the case at the time of hearing, if necessary. The petitioner denies and disputes that during investigation, any inculpatory evidence has been discovered against the petitioner. The petitioner states and submit on the basis of such selective malafide and vindictive investigation, petitioner cannot be discharged, save as aforesaid all allegations that are contrary thereto, inconsistent therewith are denied and dispute. So we have replied to 44, and how we replied, my lord, I have read this particular paragraph, my lord. Now, it start, my lord. I will demonstrate before your lordship a particular candidate. One of the candidates.
Mr. Das,
Yes.
that pertinent query, are you answering here or you will answer later
No, I'll answer it now.
regarding discrepancy in the marks?
Yes. We'll answer it.
Let
Now,
us-
my lord, to start that, my lord, your lordship I will demonstrate a particular candidate. I'll show it also. And now, my lord, will see page 21. Serial 5. Yes. 340, page 348 kindly be looked at. 348. 348.
Yes.
348, Lordship got it, my lord.
Hmm.
This is a Caesar list, my lord.
Hmm.
And the accused, Mr. Rakesh Pal, he was arrested, my lord, on 4/11/2016.
Hmm. Hmm.
When he was arrested after that, my lord, it was raided, his house was raided.
Hmm.
And on 12/11/2016, my lord, it
Yes.
was Thursday, and this is a Caesar list, my lord,
Hmm.
at 2 a.m. Now, this contains Caesar list, my lord, from page 348, from description of Caesar, lordship, got it, my lord. This contains up to 351. 351. Now, kindly see serial number 3, my lord. Serial number 3.
Yes.
349. Serial number 3. 2 APSC loose answer script having without book number, serial number, signature of invigilator,
Hmm.
signature of scrutinizer, signature of first scrutinizer, signature of second scrutinizer, packed in envelope, written as Sukaina Das, one of the candidates, similarly like me only. DIPR. Now I will show before your lordship. Now, 368 kindly be looked into it, my lord. 368. My lord, 368.
Yes.
That is 39, serial number 39.
Hmm.
This is Sukaina Das. Not you got it, my lord.
Hmm.
For this purpose, roll number will be in, kindly note down the roll number. 0500188. Now kindly turn to page 344, my lord. This is what we got it, 344. This is a FSL report, my lord. My lord, it starts at 340. Your lordship kindly note down. 340 it starts. 340, your lordship can note down 340. It is in my note, my lord. Everything is in my note. I am arguing on behalf on the notes, my lord.
Yes.
That is 340 start. 344 kindly be seen, my lord. And that is first, second, third, fourth, fifth, sixth. Roll number kindly be looked into.
Yes. 05000188. Yes.
Now, my lord, this is general study 153. Last column kindly be seen. I will not trouble with because there is last column. Optional subject kindly see, my lord. Optional subject. Original kindly say total marks. Last column. 714. And my lord, after alteration 805. 805.
Yes.
But this Sukaina Das is still continuing in the service. She has not been prosecuted. So this is what the investigation has been done by the investigating agency. Selectively, they have done it, left out, and they have picked up few of the individual. This is why I am connecting to judgment of this, the apex court. This is one of the instances, my lord.
Yes.
Now, my lord will kindly see. 394 kindly be seen, my lord. Page 394.
What is this document?
394.
This is the Caesar list only.
Yes.
Yes.
Yes. Kindly see at 98. Yes, I.
Yes.
97. This belong to Sukaina. How it belong to Sukaina? My lord, your lordship definitely asked me how it belong to Sukaina. This is what we received. 207.
Y27.
Yes, Y27. Now kindly see. typed copy, it was not possible, my lord. I have given a particular, kindly see, last page 6, kindly see, my. That is 050 00188. That is Sukanya Das. That's the roll number last 12, Sukanya. At page 6, my lord, and marked as page 6.
Sukanya Das.
Down below, that's
Yes.
Sukanya Das.
Yes.
That code is 143.
Hmm.
That's your lordship, kindly see 394 now.
General Studies Code
Code
143.
Is 143.
Hmm.
Then 157. Now
Hmm.
kindly see generally 157, that's a code.
Hmm.
So it all continues, Mike. It all continues. So this is how we identified, my lord.
Hmm. All right.
So, my lord, there are 2 answer script from Rakesh Pal,
Hmm.
6 from the strong room. So there can be only 6 answer script. There were 8 answer script.
Hmm.
2 from Rakesh Pal, which I have shown, my lord, on 12/11/2016, where they went to the house of Mr. Rakesh Pal and they seized. So what I want to show that this is the investigation you have carried out. And you have picked up. And these are
Any more instances of the nature of Sukanya Das?
I'm sorry.
Any more instances in the nature of Sukanya Das? How many?
Many others. I will show, I have made a list.
Just give a number.
Yeah, I
All
will
right.
give you a number, my lord.
All right.
Now, straight I will give the numbers. I made a list for the convenience of the court. Additional affidavit which I have filed already. Earlier, not now. I made a list for the convenience we have worked out. I am thankful to my learned friend who has worked, my lord, day and night on this issue because it's very difficult to find out. Very
Bulky
difficult.
record, voluminous record.
Code number, booklet, code number, which is said, very, very difficult to find out.
That's right.
So we find an additional affidavit which is earlier.
Must be a part of the record.
Your lordship.
Yes.
Yes, yes.
Additional affidavit dated 20th April 22.
Yes.
20th April?
20th April. Yes.
Yes.
My lord, Prem 62 onwards. Your lordship want to see some instances.
Page number 62.
Onwards. I made a list of it. This my learned friend made a list of it. There is no reply from the, because it was filed long back, there is no reply to it. Kindly see number 2.
Bhaskar Oja.
Yes, not prosecuted. Everything is in the subject code, MR number, date of seizure, everything. They did not give any reply as on date.
No, but why he should have been prosecuted? As in Sukanya, you said that there are alterations. Where are the alterations here?
Yes. Page 2, internal page 2 of this. Yes.
The why were
Of
they?
tabulation.
The tabulation we are seeing.
Yes. Because only.
But where is the alteration?
My lord,
Alteration.
alteration is page, that's what we have done. This is a tabulation. I made a list of it for the convenience. I know your lordship, where is that? So my lord will kindly take this tabulation sheet.
So we are
There is
having
alteration is here. Alteration is in the tabulation sheet.
which one? This photocopy you have given. This one.
Yes. I just find it out.
Mr. Das, unless it is specifically pleaded
Yes.
that these were the candidates whose evaluation resulted into a finding that there was an alteration,
Yes.
and yet they are continuing, or the respondent is going to counter that submission.
No, we at the read code, we did not. When we went 207.
Even in appeal,
Yes.
where is that pleading?
Subsequently, we got it. That's why we brought it by an additional affidavit.
Even in the additional affidavit, how do we find out?
But that's why, my lord, paragraph 39 we wrote, as a general, we wrote 39, my lord, 39. Each of the candidates, your lordship has said, once again, kindly see 62. If it is necessary, I will find it out from here.
From 62, let us know what does 62 mean regarding, all right, Bhaskar Oja not prosecuted. Why was he to be prosecuted?
Yes. Because there is alteration of the mark. And
Where is that written?
That is 2. Two of the tabulation sheet. Kindly see 2 of the tabulation sheet, my lord, for a moment.
2.
2.
Yes.
That is 01, Bhaskar Das, number 2. Now kindly see code. 908. 854 to 908 alteration.
Where is that written?
This is, my lord, this is 854 initially and it's 908.
Where is it written, Mr. Das?
Last column is 908
In your affidavit or in this sheet, loose sheet?
in the loose sheet,
Oh,
loose sheet,
loose sheet at page number?
page number 2. Page number 2.
Bhaskar Oja. Yes,
Yes,
908
yes,
8454.
yes.
Hmm, hmm, hmm.
So these are instances, my lord. And if your lordship kindly turn to same 62, now one Varun Kumar Bora, same. Now next 63, how are not possible? So what my learned friend has done, my lord, I have been told.
He has
that-
just identified those persons who, as per you, there was an alteration of marks
Yes.
and they have not been prosecuted.
Yes. This is what we want. And for this, my lord, what my learned friend will note it is there. He filed a writ petition before this court. How selectively it has been prosecuted. How you left out.
Hmm.
So my learned friend has filed, moved this matter 2 years back.
Which is that?
Selectively. Writ petition. Writ petition criminal 30 of 2000. We have annexed that here.
What is the fate of that?
No, that is government is taking time. 2 years when no affidavit has been filed.
You should have pointed out at the day one. We'll call that writ petition here.
No, it is a part of record also. We have
No.
we have annexed it.
Part of record is okay. But then Mr. Kohli can respond to that also.
Yes.
So where is that writ petition? What is the number?
Yes. Writ petition criminal 30 of 2020.
Call that file here.
21. So my lord, what has happened? How selectively you have prosecuted? You
Hmm.
do not have prosecuted selectively. 2 years, there is no answer to it. 2 years.
Let's get the answer. Let the file
And,
clear.
and my lord, what interesting, I have been told that when the writ petition was filed before this honorable court on 20th December, on the next day, the IO was immediately he got how this selectively, how it has been done.
Hmm.
So immediately some charge sheet, 11 number of charge sheet was filed on next day, which will bring it before the court. So that is what I am saying. How you carried out investigation, you are saying is a fair investigation. The entirety of the in-house has to look into it, my lord, which has not gone through it, my lord.
Okay, very well.
And the police report with great respect, I am saying it is all tainted, my lord. Now, my lord, this 62 onwards, your lordship will kindly see, I have given a list.
Hmm.
I have given a list, my lord, where it listed how many was not prosecuted.
Hmm.
Even they stand on the same pedestal, my lord.
Hmm.
Yes.
Hmm. Yes.
2 years. Now, so how, my lord, I will just tell you, lordship, very interesting, how this 9 tabulation sheet was dealt by the IO. That your lordship should know it, how he dealt it, my lord.
Let's see.
Yes.
This
that's
very tabulation sheet.
I'm sorry.
This
Yes,
very tabulation
yes.
sheet. Let's see.
I will show on records, my lord. Nothing I am showing beyond the record. How he kept it. My lord will kindly see at page 348.
Para?
348.
Para?
No, this paper book of 348.
No, yes.
350, my lord will kindly see. 350. Which I have shown, my lord, MR registry.
Caesar list.
Caesar. Kindly at 348, kindly say date, 12/11/2016, your lordship has noted down. 12/11. 350, kindly see at 9, serial number 9. Total 9 pages of APSC tabulation sheet of combined main examination, having roll number, name of various candidates, general study, so and so, has pinned up in a small size paper, mentioning so and so. So kindly see, this name is very important. Mentioning number Pushkar Gogoi, Hiraj Jain, Jayanta Doloy, Hemjyoti Bora, packed in a medium size envelope. So my lord will kindly see this what we got. This is the front page. Kindly see the name of the front.
Yes.
Kindly see the front page name, my lord, is
Yes.
reflected.
Pushkar Gogoi, Dheeraj Jain,
Yes,
Jayant, so and so.
yes.
Dole. Huh.
9 pages tabulation series along with this. Now, my lord, what he has done it. On 12/11/2016, it was seized. My lord, he has not sent it to the FSL for 1000 days. He has kept it in hiding. I will word the use hiding. He has kept it only to protect and seal those candidates. And it is on record. I will show it, my lord. It is on record. 1000 days he has kept it.
How was this dealt with? By the learned single judge?
Yes,
How this was dealt with?
page 27 kindly be seen, my lord, of the
Judgment,
paper book.
page 27.
27 of my paper book, kindly see. Para 38, I made a pleading, my lord, kindly see. 27. At para 37. 37 kindly be see at page 27. The same 9 pages of tabulation sheet seized on 12/11/2016 was sent for FSL examination on 8/8/2019. I'll show record, my lord. It is not my, it is backed by record. After-
That we can.
After 1000 days from the date of seizure, the FSL Kahilipara by the report dated 16/12/2019 revealed the culpability of several candidates in this report. Now, next, my lord, appellant submit to demonstrate an illustration example of the IO malafide conduct culminating into a tainted police report. Following facts are essential to be brought to the notice of this Honorable Court for proper adjudication of this appeal. Now, kindly see, my lord. It is submitted that some of the documents referred in the appeal were not available with the appeal at the time of hearing before the learned single judge. In fact, the said document was supplied to the appellant.
Now you are highlighting this tabulation basically.
Right. By the learned trial court subsequently, after disposal of the writ petition being the subject matter.
What is the significance of these names? These 4 names?
Yes, I'll come to this, my lord.
Okay.
Just the 9 pages of tabulation sheet with visible alteration of marks pinned up along with small size paper was recovered from the rented house of Rakesh Kumar Pal, the then chairman, on 12/11/2006, seized so and so along with several. Although other documents seized by MR 2016 were sent for FSL examination, 9 pages tabulation sheet was deliberately not sent for FSL examination by the IO till 8/8/2019. The answer script of all the candidates whose name were found in 9 pages tabulation sheet with visible alteration of marks were seized on 12/11/2016 by the MR number and subsequently on 6/6/2017. Although the answer script was sent for FSL examination, the said 9 pages tabulation sheets were deliberately left out. The investigation officer referred to 9 pages sheet in main charge sheet dated 24/1/2017, but the same document was neither relied as a material evidence in the charge sheet upon nor sent for FSL examination by the investigating officer in the said charge sheet till 24/1/2017. On 27/7/2017, the first supplementary charge sheet was filed naming 3 candidates accused. Although the names of all the said 3 candidates are found, the said 9 pages tabulation sheet, the IO deliberately chose not to mention the said facts in the said first supplementary charge sheet in order to shield other similarly placed candidates. Or a meeting was, now this is important, my lord. A meeting was conducted on 3/8/2019 by monitoring committee called SST, set up by the Director General of Police to closely monitor and supervise the progress of the Dibrugarh Police Station 936 of 2016. Immediately after the said meeting on 8/8/2019, after lapse of 1000 days, 2 years, 8 months and 28 days, the said 9-page tabulation sheet was sent for FSL examination. And what on 27/8/2019, the IO submit the undertaking. Now this is, I'll show the orders. Undertaking before learned trial court to submit the FSL report pending as 27/8/2019 as soon as the same is received. But the IO deliberate chose not to fulfill the said undertaking. Now, my lord, this FSL report on 9 pages tabulation sheet was prepared within a period of 131 days, and the same was forwarded by Director of Forensic Kahilipara on 26/12/2019. Now, this date kindly see is very important, my lord. The said FSL report was shown to have been received by the IO on 5/4/2021 after a lapse of 467 days after the said report was forwarded by FSL Kailipara. Although the culpability of several other candidates were apparent in the said FSL report dated 16/12/2019, even after a period of more than 325 days, as of date of filing of the writ appeal, the IO have still allowed the other similarly placed candidate to continue in government service and completed the maximum provision for a period of 4 years from the date of appointment. There are several, my lord, these are what, and on records, I will show it now, my lord. These are statements which is based on record. Kindly see. Now, record report, FSL report. Now, kindly see 61 of my additional affidavit, my.
Which you filed today?
No, no, earlier, 2022, my lord.
61.
Yes. Kindly see page 61, my lord. Kindly see this is a forwarding, my lord, from Director Chemical Examiner on 26/12/2019. Now, kindly see, please find out the enclosed report opinion number dated 16/12, DF QDS 192/219 and dated is 16/12. Now, this, your lordship will kindly mark this DFS QDS 192/219 dated 16/12/2019. In connection with Dibrugarh PS case number so and so, address section, receive your memo number dated 8/8/2019. So this FSL was received 8/8/2019, which was he received on 12/11/2016. After 1000 days, he has sent it. And now, my lord, kindly see. Now, kindly see the report number.
192/19.
Yes. That report number, I have annexed that. I have annexed the report number. 340, I'll just see the report, my lord, 340. 340 is the report. This. And kindly tally with that. Report at 340. 340 is about 9 pages tabulation sheet, my. 340. Kindly see Dibrugarh PS case dated, kindly see 16/12. 16/12. And in number DFS. Kindly see on the top, on the right, on left hand side of the top, my lord, your lordship, kindly mark that DFS QDS 192/2019. Lordship and marked it, my lord. This. So that is what on 12/11/2016, which was seized on 12/11/2016, my lord, he has kept for 1000 days. And interesting, my lord, when the FSL report was ready, my lord, the IO doesn't go to collect this FSL report for 15 months. He doesn't go and collect this.
IO is not supposed to go and collect. It is forwarded basically by post.
But it is
Normally it should be.
But what made him to hold this, my lord, for 1000 days, my lord?
That's right. Yes.
Now, this is done, my lord, with that FSL. Now, 6 of my additional affidavit kindly be seen, which your lordship is just holding. Kindly see the order of the court, which I mentioned in my paragraph, my lord, one which I read, my lord. 27/8/2019. Lordship got it. IOC so and so is present and submitted. He has completed investigation. Like my lord word, he has completed investigation and submitted supplementary charge sheet number 10 against all the arrested as well as absconding. IO submitted 2 number of SLC report are still pending. One IO undertake to submit before this court as soon as the same are received. Now. 497 kindly be seen now.
497.
497. Now, my lord, he has given the undertaking on 27/8/2000 and completed the investigation. Your lordship will read this, completed. But at page 497, 21st of December, lordship will recollect. 28th of December 2021 was our writ petition criminal. Selectively, you have prosecuted. How can you do selectively? No answer. This your lordship has called for that. Now, on the next day, 21st of December 2021, kindly see third paragraph. During the course of further investigation, mark sheet and scrutiny slips of CE 2013-14 were seized from the office of Assam Public Service Commission on 28/8/2019 by memo number so and so. Subsequent thereto, the mark sheet and scrutiny slips and were sent to FSL for comparison and expert opinion with respect to specimen handwriting, other exhibit document as per the order dated 13/9/2019. My investigation was completed. After 5 years, he won this. After 5 years, marks sheet and scrutiny sheet. I'm just showing the conduct of the great respect to the IO. He may have done a job, my lord. But this particular report, we can't, my lord, your lordship will not take into account his report. These are fully doubt, my lord, report. And if I can convince on the face of it that these are tainted, then my discharge itself is bad. Then your lordship has not to go into the second aspect, which my learned senior friend argued on a stigmatic. Because discharge and stigmatic. So, my lord, we'll look into. Now, my lord, will kindly see 472. 472, my lord, kindly see. 472.
Yes.
Last para. In addition to the facts averred in the earlier supplementary charge sheet number so and so, another facts came in notice in course of further investigation. One single estimate sheet, smaller in size of 9 loose tabulation sheet discussed above, was also recovered and seized from the rented house of the chairman. Lordship got it, Mike? Of so and so. And so on dated 12/11/2016, wherein the name of 821 roll number so and so enclosed collected on, kindly see say 5/4/2021. Here is mentioned when is collected. On 5/4/2021 during further investigation. So after 15 months, this is what I want to show you. My lord, 464 is a date when we file the writ petition is on 20/12/2021. On the next date, my lord, kindly see 21/12. Kindly see that, my lord, on 464. 464, I've just top corner, my lord. Top corner on 464.
Yes.
21/12/2021. And writ petition was filed on 20/12/2021.
But you can't connect the filing of writ petition with this report, basically. They would not even be cognizant of the fact that you have filed any such writ petition.
Copy was served.
You see that
They
kind
are
of
sitting, my lord.
that kind of communication can you expect?
What I want to show is, my lord, what
Because
type of
preparing this report would not be
my lord,
possible overnight.
what I want to show to demonstrate what type of investigation they have done.
You already argued that, yes.
I will not trouble your lordship much. Now, page 350, Pushkal Gogoi, your lordship was asking that what is the fate of that? 3, my lord, what that Pushkal Gogoi, Virat Jain and Jayanta Doloi. Kindly see page 350. My lord, 350. The names your lordship has
Names
seen.
are there, yes. Yes.
Now, 472 kindly be looked into it, 472.
Hmm. Hmm.
That's it.
In this report, Mr. Das, in this report, does the IU deal with this aspect regarding increase in marks of the candidates who have not been charge sheeted? Does he deal with this in this report?
Yes, I will just show that.
He must have done that.
Yes,
Something must have been done.
483, kindly see my lord, 483,
Yes.
483. 17.7. 17.7.
Hmm.
The
Yes.
recovery of one single estimate similar seat in size, 9 loose table, lots of got it.
Yes.
So and so House of Chairman, so and so, at so and so 12/11/2016, when name of accused Harshita Bora, Harshadati Bora, A21, along with his roll number, appears with name 3 others, Pushkar Gogoi, Pushkar Gogoi, Dhiraj Jain, Joyanta Dolo, also established there was a criminal conspiracy between Sri Rakesh Kumar Pal and the candidate for securing job in lieu of illegal gratification not on merit. This is none of a business in respect of chairman. This is what my lord. Now, my lord will kindly see interesting facts. In course of further investigation, there are illegal enhancement of marks in the final tabulation sheet in respect of the aforesaid 3 candidates, Pushkar Gogoi, Dhiraj Kumar Jain, Joyanta Dolo also, and without such illegal enhancement of mark, these 3 candidates also could not make the selection, not only the present category, but even to any other LS serving so and so. But so they are not been made accused in this case.
They have been discharged or not?
No, they have not been accused.
No,
They are continuing the service. This is what I am. But these are all. You how can my lord you all rely this the police report? What is this investigation, my lord? No, it has been charge sheeted. They are continuing in the service. After this also, they have not been made an accused. My lord, one Pushkar Gogoi, I'll just demonstrate about Mr. Pushkar Gogoi. That 368. The material was what was collected and what was before him at page 368. 368. Serial number 40 at page 368. 368.
Yes, please.
That is 40. Roll number, kindly mark the roll number 0923789. The Lord will just mark the roll number. Now turn to page, my lord, kindly 341. 341. The roll number is 0923789. 8 row, my lord. No.
331. 3789. Yes. One original 130.
Yes.
180 after alteration 180.
Yes.
So total marks 843.
Yes.
793.
Yes.
That is right?
Yes, right. So kindly see the alteration, my lord. This is alteration. So this report was there before the IO. Now kindly see 394, my lord.
392.
394.
4. Yes.
Serial number 98. A lot of 6 answers sheet marked as Y28 containing general studies, quote number 1187. So and so, so and so. So this is in respect of Pushkar Gogoi. Answer sheet recovered and this 9 they identified through the 9 pages separation. And this is continuing in service.
Okay.
A tabulation sheet, your lordship, just mark it, it has page 9. Page 9 in a tabulation sheet. Serial number 11. 11, it is reflected 10, 11. Only 11. Only 11. Postal row. Only 11, my lord. Page number 9 of the tabulation sheet.
This loose
Yes,
sheet you're given.
Yes,
But there, it is there in the FSL report only.
yes.
Page 341,
Whatever I have seen this.
it's already there.
Code number has been identified.
The roll number is there, no?
Yes.
Yes.
Answer script recovered in 2017. Answer script 2017. And what segregation they have done it by. So I don't want to trouble Dhirajan and Jayanta, your lordship has seen that. Now, my lord. 408, kindly see 408.
Yes.
This is another Caesar list of 2016, my lord. So it was recovered from the house of one of the member of APSC, Basanta Kumar Doloi. So these were found. Description of Caesar, 26 number of duplicate cards, certificate of various exam, all these were found. 409. And so these all incriminating materials of these various candidates were found. But after a period of 5 years, this was mentioned. That is 481, kindly see, my lord, 481. Page 17.2 as 481. See, my lord, 17.2. Further, the recovery of 26 numbers of admit card, certificate of various examination.
These are not a part of the earlier charge sheets. This fact has not been mentioned.
No. Now kindly see, further the recovery of 26 number of admit card, certificate of various APSC and 13 number of small pieces of papers by MR, wherein names and roll number of candidate wherein written from the house of accused Basanta Kumar Dole, AC is clearly established his involvement in the entire episode of illegal selection of candidates in various exam and procurement of government jobs through APSC. On bare perusal of this Caesar document is seen that there has been call letters for interviews viva of various candidates of post of ACS and allied service under CCA 2013-2014 agriculture. Now, my lord will kindly mark this, my lord. Kindly mark this agriculture development officer under agriculture department. Others were accused. Basanta Dolo was also one of the members of the interview. Hence, being a member of interview board for such interview, so and so Basanta was not to have been possession of document number so and so. Now,
Devajyoti Gogoi, he is also, she is also terminated?
No.
Discharge?
My lord, interesting. Interesting. My lord, what has happened? My lord, I'll just give 2 minutes of background. My lord, when Rakesh Pal was arrested in this case, so he moved before Supreme Court about his bail. So after certain periods of time, the appeals court said yes, we'll release him. Now, default bail he got it. Now, only to keep him in custody, they registered another case, Bhangar PS case. In respect of all these agriculture, this officer, ADO. One interesting ADO officer, still today they are being prosecuted, but they are continuing in the service. Similarly appointed of Rakesh Pal during his term.
In the same selection process.
Same. And they are continuing criminal prosecution of all these ADOs, but even they are continuing with the job. This is, I can give your lordship the number of Bhangar PS case number. I have annexed it at page of charge order as page 8, earlier additional affidavit we have got. Kindly see at page 8. It's a big order, I don't trouble. 18/12/2021, which starts at page 8. Only relevant part your lordship will kindly see at page 15. 15. First, second, third, fourth, fifth, sixth, seventh, eighth, ninth, 10th line. 10th line.
Yes.
Accused name Regan Haloy, Anindra Sakya, Pranab Bharali, Jyoti Rekha. So all this, all 36 candidates, my lord.
Sure.
When I remember, my lord, when initially when I joined, whenever I used to sit, I said, why don't you go out? Initially when I joined. Yes. Yes. Now, my lord will kindly see 15. The last, all these names where the candidate for the post of ADA conducted by APSC. Lordship, see the word. They are still retaining in service. Same selection. And what charge sheet was filed, although charge sheet was filed during provision period.
Okay.
So this is what I just want to project before your lordship. Yes. Then it is gone. I have just few, my lord, 2, 3 here, and I just.
Where's the next date? इसको फिर Tuesday कोई मंगाना. Call it on Tuesday. Next when we hear this. कोई बात नहीं. Just we need to have the look at the file. नहीं, just like that.
My lord, at this.
Yes.
At 486, kindly see the 17.14. After 5 years of investigation, my lord, 5 years. Now, 2021 is at 17.14. What they said, you kindly see, my lord. During further investigation, revealed 42 OMR sheet pertaining to so and so 2013, 47 answer script pertaining to 2000 could go missing from the control room of the APSC. Such incident of missing OMR so and so could not have occurred unless those answer scripts were selectively removed from the active connivance of so and so. After a period of 5 years, next, my lord, kindly see, during investigation, it is came to notice that though there have been rules to maintain double lock system to the principal controller and chairman of APSC in terms of so and so number, but the norm and requirement was merely flouted, even to the extent of maintaining one of the keys to Pavitra Koibatra and the assistant controller of examination. But I have been told this Pavitra Koibatra, he is accused in this particular case. But principal controller has not been an accused in this case. But whatever I am showing it after 5 years.
Okay.
On 384, my lord, at page 384, and that is on 6/6/2070, he sees all the answer script, my lord. 6/6/2070. Can you see page 384?
Yes.
So, my lord, if he has seen all the answer script, why he did not seize all those answer script, my lord, 2021, why he has seized after 5 years?
No, Caesar is not after 5 years.
No.
Where do we get it that Caesar is up?
384, my lord. 384.
Yes, this Caesar is of 2000.
2017.
So what do you want to argue?
No, what I want to show before a date of Caesar, he sees everything. He could have seized that also. After 5 years, what prompted him to seize all those?
What has been seized after 5 years?
Yes, my lord. He said that it has gone missing, my lord. This is what he stated.
At page 486.
Yes.
Oh, no.
After 5 years, he said that these are gone missing.
Could go missing. That's what he says.
Yes, could go missing.
Hmm.
So this what I am saying, my lord, see, so.
No, this conclusion has been written after 5 years, but the fact of the files having gone missing or the OMRs having gone missing was collected by him long back.
Sir, he has not collected. That's the whole, my lord. Whatever he should have done in 2017.
Hmm. Okay.
Then this is what is done, my lord.
Hmm.
Then,
Hmm.
my lord, 481 kindly be looked into it. 481.
Hmm. Yes.
Last paragraph kindly see, my lord. Shocking revelation is that out of the aforesaid Caesar document, one call letter, so and so, pertaining to one candidate seat, Debojyoti Gogoi, bearing roll number who eventually got selection in the select list, category of so and so, was also found and seized. This chapter of matter clearly indicates about the secret agreement between Debojyoti Gogoi and Dr. Vasanta Kumar Doloi in getting the job illegally. But he is not an accused, he is continuing. So
She,
Yes.
not he.
Yes.
Srimati Devajyoti.
Yes, Srimati.
But question is when these facts came to light, before confirmation or after confirmation?
Which one?
Regarding this revelation, when was this revelation made?
Yes, before 2017, my lord.
This entire, this is the first chart sheet
Yes.
you are referring.
No.
Then?
Large chart sheet. This is a
So
large chart.
that's what we want to know.
Yes.
When was this disclosure made? Because he is filing this conclusion in 2021. So when this fact came to light,
What I'm saying, he kept all in hiding.
Hmm.
He kept in all hiding, only to shield that, so that they get confirmed. Only
Okay.
for that purpose.
Hmm.
So why he has not been made an accused? I'm asking myself. He is not. been made an
Why this lady has not been made?
Yes,
an accused?
why it is not been made? So why not Pushkar Gogoi? All this, my lord, why I'm saying that the
Investigation is tainted.
Yes,
That's
that's
what.
what I am trying to.
Understood.
Yes.
Okay.
I'll tell your lordship that my learned friend has said 18 occasion was given to the IO for further investigation. of it. That's only for your lordship.
That is okay. That's permitted, Mr. Das. That's not a problem.
Because it was a court monitor investigation. my lord. That's why 18 times. Maybe it's given, my lord, but kindly see in what manner he has done it.
Mr. Nath, who is appearing in that criminal writ petition before single bench? Given the file, just check who is appearing. Why the reply has not been filed in that?
I'm checking.
Criminal, your case. The government. My learned friend appeared and he moved. All
Who is
these
appearing for the government?
government. I think my SS Joy, I think some SS Joy appeared and he took time.
You let us know, Mr. Nath, why affidavit has not been filed in this matter till date. Yes. Yes, please.
My lord, this criminal part is over now.
Very good. Now what?
Criminal part, what we are saying that these are all, your lordship cannot accept. These are all tainted police report. So if it is tainted, then the candidates, overall candidates should not have been discharged. And if it is now, if for a moment, if your lordship holds that it is not tainted, then discharge, likely they have done discharge. Then the question of stigmatical, whether they were required to give it. So in the present case, my lord, there is one more candidate, Suranjita. I'll just take one, I can finish it today. I'll finish it. It takes about 1 hour time, my lord, to finish it off. By 1 o'clock, I'll just close this, my lord.
Okay.
Next, after my lord, I'll take half an hour to finish it off.
Sure.
My lord, now it's for a moment, your lordship decides that no,
That
we
the
are not-
investigation report is not tainted, it could have been acted upon.
then by stigmatic. Whether
Yes,
the
that's,
order is stigmatic.
even if it is not commendable,
Comment.
it could still have been acted upon.
Whether
Okay.
a notice is required,
Hmm.
much has been said by my senior friend, Mr. DK Mishra, only to add up.
Hmm.
So what I will just draw your lordship attention is regarding about the rule, because this Malloy
Hmm.
belongs to a taxation,
Hmm.
taxation rules by. This rule is under 19(2).
Hmm.
Where is the rule? 19(2). It is in the compilation of the.
Compilation,
I think.
Which one?
19(2) of the taxation. It is on the phone.
which compilation? Would you be handing over these on the next Tuesday when Mr. Kohli addresses? You hand over this list at that point of time.
Yes, yes.
You provided this list to him?
Yes.
Mr. Nath,
No, no, no.
have a list with you.
I'll take a
It's
copy.
important.
I'll show you. No, no. My lord, if your lordship kindly
Yes,
take the note which has given yesterday,
this is also written. Note,
note which I yesterday I have handed over.
where is that note, Mr. Zakir? Yes, yes,
This
Mr.
is note, I think, this is what I given a note.
Yes.
The appellant was discharged from service on 12 to 2019.
Hmm.
Under 19(2) of the Assam Tax and Service Suit, 1995 treating him as a provisional.
Hmm.
Now, my lord, 19(2),
On 12/2,
12
on
to 2019. Now, my lord, it is Roman 2, kindly see, my lord, they invoke 19 Roman 2.
Hmm.
If it is found on a subsequent verification
Hmm.
that he was initially not qualified for the appointment,
Hmm.
or that he has furnished any information, incorrect information with regard to his appointment.
Hmm.
So they invoke this particular rule.
Hmm.
Now, my lord has seen in this, which the order is very innocuous, then you have to lift the veil and we have to find out.
Hmm.
Which, my lord, the exercise was done
Hmm.
by the learned single judge, which it reflects. The lifting of the veil. They found what the initial entry itself, what you were saying, initial entry, they all bribe, no merit. So it doesn't need any consideration. All and misconduct will be only post-recruitment. You are not entitled any notice on the pre-recruitment. This is what, my lord, with great respect, which a learned single judge is a finding.
Hmm.
Then, my lord, I'll just give a reply. My lord, the stand of the government in this case, I'll show it that their stand is that rule is applicable. All this action was taken on the basis of the rule.
Hmm.
All the action.
Ms. Das will continue at 2.
Yes.
Yes. Hmm. We have already, you have quoted it here very well. Hmm. 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 $96, yes. Hmm. Page? Hmm. Hmm. Yes. Hmm. 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 19.2 is not stigmatic, Mr. Das. Hmm. 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 Yes, please. Hmm. 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 Yes. Hmm. 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 Colossal for. Hmm. Hmm. 2,504 means during his tenure. Okay. Hmm. 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 Hmm.
So this was the two-fold of prayer which was made before this honorable court. Now, the honorable court, what is done, my lord, honorable court has directed that what we'll do, a commission of inquiry by a retired judge, one should be appointed. That this was said to the government, that you appoint one retired judge for the commission of inquiry. Now, secondly, the Rakesh Paul CBI inquiry, that preliminary inquiry, my lord. But these two subjects was put to challenge when the order was passed before the apex court. Apex court has stayed this order of the High Court. State. Only CBI inquiry was stayed by the apex court. CBI inquiry. But so far the commission of inquiry that
Probably on the ground that two prosecutions or two investigations of same fact, maybe on that premise.
No.
At that point, then
there was no FIR. There was no FIR at that relevant time, my lord.
Okay.
So because he get a protection on 317,
Yes.
is a constitutional post.
Okay.
So until governor
Yeah,
has
unless
to
prosecution
refer to referendum, my lord. So this part, but ultimately the time elapsed, my lord, that he didn't, because there was no adjudication on the merit of the case because time elapsed. So that's the why, my lord, that was state. CBI was state inquiry. But so far the other part regarding commission of inquiry, that was there. The High Court judge should be appointed to look into these affairs. Now what has happened, my lord? Thereafter, when the SLP was not dismissed, they came and they filed a review application before this honorable court, which I brought in notice by before this honorable court, by the state. They doesn't want that commission of inquiry should be appointed.
Okay.
This is on record. And there is also a letter. Because
what is the fate of the review?
No, review has been disposed of. That's why BK Sharma Commission dismissed.
Okay.
So this review we have brought into at page 49, my lord. Additional affidavit which have filed long back.
Okay.
49. Just putting it before the court. Page 49, your lordship can note it. And 49. State has preferred. Lordship, just note down at page 49. Review. And my lord, kindly note down one page, my lord, of the review order, page 56, paragraph 19. Just I will read this paragraph. This is additional affidavit, my lord. 19, paragraph 19. To the extract of the letter dated 23/7/2015 is annexed, an extra 4 review petition reads as follows. So my lord will kindly see date of appointment of Mr. Manas Pratim Haloy is 26/8/2015. Just your lordship can note his date of appointment 26/8/2015. Now the extract of letter is annexed. This is Chief Minister dated 23rd of July. Dear C. Arsa, kindly refer to your letter dated 7th of July. It has been decided to institute a commission of inquiry under the appropriate provision of Commission of Inquiry Act for making inquiry into allegation made against APSC, Chairman APC, etc. So this has been written by my lord, the Chief Minister, Dean and Chief Minister to the Governor. Now, before appointment, inquiry was made. So before appointment, my lord, inquiry was made. It is not the case that they have stated only after appointment we have come to know. Before appointment, some exercise has been done by them.
Governor, in that letter, if my lord calls for the.
And if this, what is that letter of 7th of July 2015? That's the my lord, which is not with us, my lord. Definitely it will be the state, my lord.
But the governor recommended the no.
What we have been told, the recommendation by the governor is that don't make any appointment. Don't make any appointment. Your lordship will, we can look into it because they can produce the letter is with the government. Don't make any appointment.
Yes.
So this is a position, my lord. So before entering into the service, my lord, some verification was conducted, which they stated in the affidavit, that only after appointment they have come to know. So pre-recruitment, my lord, there was some verification which was done. This is what I am just stating before your lordship. And secondly,
now, Mr. Das,
yes,
what is the order dated 15/10/15? Where is that order?
15/10,
which is of which the review was filed.
Yes. My lord, where is that? At page 51, your lordship is quoted. 51. 51, my lord. Paragraph 7, kindly see, my lord. Paragraph 7. The petitioner environment in PIL disclosed the state government has constituted inquiry committee to be headed by retired judge of court to inquire into allegation, anomalies and malpractice. The allegation with regard to anomaly and malpractice cannot be efficaciously decided in writ petition. Allegation relate to factual facts. In that view, commission headed by retired judge of the court would be appropriate forum to go into the issue of allegation of anomalies and malpractice in the conduct of examination. It is just and proper that petition can put forth their case before the commission. It is stated judge is yet to nominate by the government. We direct the government to nominate the judge within 1 month. The terms of frame for Subhas Das committee should also be framed for the commission to examine. In addition to terms of reference should be comprehensive to include any type of malpractice in paper setting, valuation, moderation, viva, including the competence of experts. Chosen for paper setting and valuation should also be part of the terms of reference. Therefore, with the appointment commission, the question of irregularities and malpractice conducting examination have to be decided by commission to be headed by a retired judge of the High Court. This is what your lordship is asking. This is what it said, my lord. But that, my lord, commission of inquiry was appointed, BK Sharma, and my lord, I brought this into notice of the court, how they have dealt with the same, my lord, the CC 2013, when they found 39 more anomalies were there. And the commission says they can furnish the report. They said that it is impossible. You all has to go. Okay, kindly see now page 47 of this additional affidavit, my lord. This was circulated to internet, my lord. Cabinet is meeting, my lord. Kindly see page 36, page 47, my lord. The cabinet is meeting dated 11 April 2022. Examine the report of Honorable Justice BK Sharma Commission regard to malpractice and conduct of CCE 2013 by Assam Project. Cabinet noted, apart from 39 candidates who were already discharged from service, Commission has also examined another 34 candidates and found an anomalies of various nature. However, the Commission in this final recommendation has inter alia recommended to the government as follows. The basic averment in the charge in the present case is not with regard to the taint, which is attached to a specific group of persons, but to the sanctity of the entire recruitment process as a whole. Needless to say that when the credibility of the entire CCA 2013 stand vitiated by systematic illegalities, the issue then is not about seeking to identify the candidates who attend. That's what, my lord, morning you all recollect. This sanctity has to be looked into it. But this is the, my lord, are we, my lord, commission of inquiry, a retired judge? This importance has to be given rather than, my lord, with great respect, the police report. And now interesting. If this was the case, my lord will kindly, next paragraph, kindly, the commission
This report
therefore
is subsequent, Mr. Das.
Yes, I know.
This report is of a much later date.
Yeah, correct, my lord. Subsequent, I am showing it, my lord. The commission therefore recommended that it is entirely upon to the government to take a decision in view of the aforesaid finding. Now, my lord will kindly cabinet, my lord, I think my learned friend, additional AG, Nalin Kohli was also
a member of the committee.
5 in the committee. Now, what the reference, kindly say terms of next page, my lord, 48. This is what I was, my lord, I was a bit disturbed and I am pointing out. Similarly situated, what steps they have taken, kindly see. Whether the entire result of 2013 civil servant exam be set aside. In case the above is recommended, whether the candidate would be entitled to notice and consequent hearing following the basic principle.
Naturally, now that's almost 8 years, Mr. Das. So they must have been confirmed now.
No, what they have done it. So on the, now why they have taken, they have confirmed, your lordship, know how they have sealed it. all those candidates. How dare, that's why I thought, my lord, first all were arguing on the principle of natural justice. I told that whether I will be able to my satisfaction to convince regarding tainted, non-tainted on the basis of police report. I know that your lordship will give a patient hearing. That's why I was going through the entire, showing certain example before the court, how they have done it.
Mr. Das, why this statement? Any other judges of this court, do they hesitate in giving you a patient?
No, because these are, my lord, so many days. I know, my lord. But you see, my lord, going into all this factual, each and every, my lord, we have
It's
seen.
not a small matter that we can just brush it aside in a day's hearing.
My lord, kindly see the next, my lord. In view of the differentiating, now kindly, this I see bit of a shocking, my lord, kindly 3. In view of the differing nature of omission, ranging from increase of marks, change of answer script to complete absence of answer script, which has come to light, would the action be uniform or graded, depending on the nature of irregularity? To arrive at a conclusion, the committee may also interact with other stakeholders, retired and serving civil servant, members of civil service, etc. Committee will submit report within a period of 2 months. The cabinet also decided regard to irregularities at 2014 exam, a separate commission of inquiry will be set up by a retired judge of High Court, which will be done. This, I think, which is going on 2014.
The second report of
2014.
Okay. Deliberation who are more tainted.
Sir, now how can you?
So 2013, the report is already there.
Yes.
But they have referred it to another committee.
Yes. And they said, now, my lord, they now will find out which is more tainted, which is less tainted. Can it be, my lord? This is for, that's why I want to show before this court, my lord. And you keep all these candidates hiding, shield these members and get this confirmation. How you have done it?
Then you find out who was more tainted.
Then next. This is what my lord did. And secondly, in this respect of this, my lord, taxation service rule, my lord.
Rule 25.
Rule 25. Kindly see Rule 25. My lord, unlike ACS and other, there is a provision for increment, which my senior friend said the first increment at Rajasthan High Court. First increment, second increment once he get it. First increment is as provision.
During provision.
Yes, my lord, you don't have any rules regarding 25 like that, those of other, my lord, ACS rules. But what it says 25, kindly see in my lord, except as provided to the condition of service of the members in respect of matters for which no provision has been made in this rule shall be the same as are for the timing applicable to other officers of the government of corresponding status and having similar function. So this is what it can be borrowed from the ACS under Rule 25. That's part of increment.
Second part of second increment.
Yes, that's part I want to show before this court.
Increment, it says only after confirmation, I will get the second.
So increment, my lord, is only after confirmation, only second increment is entitled. I'll get it. That is 25. 25, my lord, of the Assam Civil Service. I think that has been already addressed. I don't want to trouble your lordship. Only just note down, my lord, 25 increment. Only.
And 157 increment.
So your clients were also given second increment?
Yes, 167. 167 of the paper book, 167. Second increment.
44, 47, 47, 49. So he started from 44, then he reached 47, then 49.
My lord, kindly see 167 of the paper book.
Yes.
That is 167, 44,788, 47,022, 47,9022, then 49,274. So this increment was given. So I think I will also try to adopt that second increment only after confirmation. I don't know trouble. That's my submission, my lord. And second, next. Now, discipline appeal rules, my lord.
kindly look into the
Discharge.
well, you should this. There is some discipline appeals.
Can we take up the discipline appeal?
Discipline appeal will kindly take up my lord discipline appeal leaves.
Disciplinary appeal rules the.
Yes.
1966, 426. Penalty. Once this is dismissal from service, which can ordinarily be disqualified to teacher.
I think same book, same book. Yes, that's page 431.
Yes.
So nature of penalties kindly see 7. Lordship turn to 432 and kindly see Roman 7. Dismissal from service which shall ordinarily be a disqualification for future employment. So this is the highest penalty they have levied on me. That
So-
future employment, this is stigmatic order. This is what my argument is.
Where, how does the order say so?
No, that's order itself, your lordship.
Let's read the order again. Let's read the order again.
No, what we are saying, my lord, in this case, Manaspatim Haloi is innocuous order. It doesn't spell out, which I will argue in the next case. But here, my argument is procedure and penalties under 19.2. So that is stigmatic. That's my argument, my lord. Procedure and the penalty, if you read 19.2, it is a stigmatic. That's my argument, my lord.
So you come to the explanation, clause G
of
discipline appeal rules.
Yes.
7, explanation, clause G. Explanation, first read.
Explanation.
Explanation.
Yes.
Following shall not amount
Following
to.
shall not amount to penalty within the meaning of this rule.
And then G.
Now G. Termination of service of a government servant appointed on provision during or at the end of period provision according with terms of his appointment.
Or
And
the
order-
rules.
Or the rules.
Or the rules.
And order governing provision.
So even if it is under rule 19,
Yes.
this is not stigmatic. It's not a penalty. It's very clear.
But now, my lord, the question now will be looked into it. But the motive or foundation. Only after.
So your argument based on these rules.
No.
That doesn't stand basically.
No, but the lifting of the veil is important now.
That's a different argument entirely. That argument has been extensively referred to by Ms. Chaudhary and Mr. Mishra also.
That I will not trouble this about a foundation and the motive which they try to bring the government on the basis of the first affidavit and the second affidavit. They try to improve. One thing I like to bring notice to the court. If your lordship kindly see the first affidavit, it is based on foundation, it is on record. When the second affidavit was filed, they want to improve it by filing an additional second affidavit and it is on the legal advice. Lordship has looked into it, it is on a legal advice. Because your lordship said that definitely they will try. 283 kindly be seen, my lord. 283. 283, my lord.
Filing affidavit on legal.
283.
283 kindly see last. The statement made in the aforesaid affidavit true to the best of my knowledge and belief based on official record and legal advice received.
First read in this affidavit where they have said that it is taint.
I'm sorry.
Where they have said in the affidavit that the order is stigmatic or action is based on. You want to say, point out different stand in the two affidavits.
Yes.
Please
The
briefly.
foundation and motive.
Yes. Briefly refer to
that
this.
your lordship will see on the first affidavit, which page first affidavit. First affidavit 244. 244.
Yes.
Kindly see at paragraph 8.
Paragraph 8.
Then when the information received by Department of Tax in respect of concerned tax officer, same was verified from the report submitted by Dibrugarh Police in April 2018, a conscious decision was taken to invoke the provision of Rule 19.2 of the Assam Tax and Service Rule 1955 to discharge the concerned officer from service. It is stated the foundation and the said decision was based on the information received and its subsequent verification. From the report of Dibrugarh Police, which constitute just and sufficient reason to believe concerned officers were not qualified for appointment to the post held by them in view of serious anomalies in the process of the selection. It is further clarified that while taking such a decision, the state respondents were not interested in asserting the truth or otherwise pertaining to the culpability of the concerned officer in the matter of the selection. Decision to discharge them from service was taken in public interest for maintaining probity in the matters of public. And now, which they have taken this stand, what they want to say, they want to say public interest is more important than your principle of natural justice. Now, if that be the case, then the judgment of the Supreme Court, with Inderpreet Singh Kahlan, my lord, paragraph, I'll show one line of that. Kindly see the judgment, what it says. So this particular stand which they have taken is a contrary to the judgment of the Supreme Court, my lord. There are 51. 54. My lord, kindly see para 54. 54. This court, 54. This court repelled a contention raised therein, and in view of the finding of Public Inquiry Commission that there has been tempering of marks in respect of several candidates, and as such there has been no fair and objective selection. Public interest demanded annulment of the entire selection. This court held that the same could not be done, at the same would tantamount to gross violation of principle of natural justice, which cannot be brushed aside on the ground of the public interest demands annulment of the selection. Now, if your lordship kindly see the affidavit 246, 246 says decision to discharge them from service was taken in public interest for maintaining so and so. So you forget all the public principle of natural justice, and on this you decide to discharge our service. So public interest cannot override the principle of natural justice. That's what it says. That's my respectful submission on this point, my lord. Now,
what is the change in stand in the subsequent affidavit?
Change stand. Now, my lord will kindly see. Stand in second. This starts
246. 246. 246. 246 यार बा.
अरे कोविल होती है
कोविल ना ठीक.
What is the stand my lord is asking in the second affidavit? What changed? Because there is a motive which they have brought, my lord.
Page 274, paragraph 61.
274, my lord. 274 at paragraph 61.
Yes.
61. It is most respectfully submitted that it is always open to the state as an employer to have regard to any preliminary inquiry, including the investigation carried out by the police in the present case. Such material would form the motive for discharge of the petitioner from service and not the foundation thereof. And as such, the discharge order cannot be said to be stigmatic in nature. Any contention to the contrary would be unsustainable law.
Page 269.
And my lord will kindly see 269. Para 49. Para 49.
Yes.
48. 49. Having regard
Having regard to the above mentioned fact, disclosed is a supplementary charge sheet filed with the police. Service of the petitioner who was serving on temporary basis was found to be unsatisfactory, and further it was found that the appointment to the public office had been secured by the petitioner through fraudulent means. As such, a petitioner was found to be unsuitable for occupying a public office of trust, and as such, the order discontinuing the petition of service is entirely legal and valid. So this is the contrary stand they have taken in the subsequent affidavit which they have. One was foundation, second one they brought it by a motive. So this is what my humble submission before your lordship, that if your lordship holds ultimately that the police report is tainted, then all discharge is bad in law. If the police report is not tainted, so discharge they have rightly done, then whether the action of the government of 19.2, the provision, whether it is stigmatic or not, whether a notice was prepared or not, because they have what they have done, it is a colossal fraud. Then of course notice is required. When you are segregated and see the conduct in what manner they have investigated, so at least a notice was required. This is elaborately it is argued. I will not trouble again. I prepared, but I thought that to stop it, because again, my lord, going same repeating, I don't want to repeat.
Governed by service.
Now, they stated in their affidavit by the government, my lord, kindly see the affidavit of the government, that it is governed by service rule, which is paragraph, you just tell the paragraph. Only your lordship will note down. That's, my lord, they have taken a stand, the government, in page 245. Your lordship kindly note down the stand of the government. Page 45 in para 8, last line, 245. Yes, a conscious decision was taken to invoke the provision of Rule 19.2 of the Assam Taxation Service Rule. So this is what they have taken. Next, my lord, 264, paragraph 264, kindly see. Page 264, sorry, 264, para 34.
Yes.
Kindly see para 34, 264. The members of Assam so and so petition govern provision of Assam Taxation Service Rule 1995 and so and so, so and so. Disciplinary appeal rule. 268, para 47, my lord. All your lordship will find in the note itself. 268, para 47. First three lines. While the petitioner serving on temporary basis responded by notification, extra power conferred on Rule 19.
So 19 is discharge of a probationer.
Yes.
So what is wrong in it? If
no,
they are
what we are
referring
showing, that once you get an increment, it is not the second increment.
different argument.
Yes.
That's a
No,
different
yes, that's right. It's in provision. But what we are trying, that we are not a provisioner.
That argument is a different argument, that once you had completed the period of probation and you were granted increments, then you were deemed to have been confirmed in service.
Yes.
More so because that subsequent order, as per you, has not been gazetted.
No, that's in APS case, my lord.
APS
case.
Therein here, there is no question of
Yes.
gazetting in this service.
Yes. So now, my lord, this is the stand which this is what.
What is the provision of confirmation in this service?
This service, my lord,
Extendable up to.
Extendable.
Further to 2 years.
2 years. It was
No.
extended.
How long can the probation be extended?
4 years.
Yes.
Under the service
Yes.
rules.
4 years.
It is 2 years, then extended to further 2 years. Can be.
2 years, it can be further extended to more 2 years.
So that is the discharge was within the extended period, extendable period. we can
Yes,
say.
yes.
And is your deemed
there-
confirmation, you are referring to the ACS rules.
Yes, correct, right. So this is about Manas Pratim Haloi, my lord. If your lordship finds that it is tainted, first case is about the gazette notification. This your lordship have to find it out. They have to place it before the court, whether a gazette notifies or not. That's the only what they have to give an answer to it. But arrest will also remain, cover up with the police report in all the three cases, my lord, which I am appearing. And second is about Manas Pratim Haloi, which I have already argued before, lord. Last case, which I am arguing, is one Suranjita, my lord. She is into the transport department.
Now, your lordship was asking
About stigma.
about the stigma part. And all the orders which was placed, your lordship's view is 19.2, it appears innocuous, it may be, but how it is stigmatic? There has to be some format of stigmatic. Where is the order? I think this is the only case, my lord, where totally what they have, my lord, I'll just read the order.
Rate appeal number.
Yes, writ appeal number 14 of 2022.
Serial num-
Item number 14.
Item number 14.
Rate appeal number.
Writ appeal 14 of 2022.
And serial number is also 14.
Item number 63.
63, my lord.
Yes, yes, please.
You have to be very fast. Why you are so slow? So, first kind, that has been quoted in the judgment of the learned single judge, my lord. That order has been quoted by the learned single judge. Entire order. But if it is not inconvenient.
That order is that para?
Yes, I'll just judgment of the. I'll just see the para. That makes it more easier, my lord. The judgment of the learned single judge. Yes, at page.
At page 550.
550, my lord, of the judgment. Paragraph 5.
5.3.
5.3, my lord.
5 Roman 3.
Roman 3. Oh, the 15 is I know. That's going to be the last. Roman 3, my lord. 550. 550 of judgment, it is quoted. Kindly see, my lord, Roman 3.
Yes.
Whereas Srimati Suranjita Hajarika, which I am pairing, wife of so-and-so, recommendation of APSC white so-and-so. Suranjita was appointed temporarily as DTO as per notification dated 15/10/2016, who had undergone 2 weeks joint induction training course along with the provision of ACS, allied service conducted by so-and-so. Whereas after completion and release from joint induction training course, white order dated Hazarika DTO provision had joined in the Commissionerate of Transport on 31st of October 2016 and subsequently was posted in a regular place of posting. And whereas a report has been received from the Commissioner of Transport Assam white letter dated 27/2018 that Srimati Suranjita Hajarika DTO, Transport Officer Pool and DTO licensing Kamrup was arrested on 18/7/2018 during a probation period in connection with Dibrugarh PSK number and detained under custody beyond 48 hours. Whereas during investigation, the examination conducted by APSC, the answer booklet was seized under 27 of the Indian Evidence Act from the convener group of APSC building, which was of the CCM 2014-15 from the ACS and Allied Services and was sent to FSL Guwahati for forensic examination by observing all the formalities. Whereas during the course of investigation, Srimati Hajarika District Transport Officer was arrested on 18/7/2018 for evidence opined by SP Dibrugarh for seizure of fake duplicate answer script. And whereas, as per report of Srimati Sri so-and-so APS, Additional Superintendent of Police, Suranjita Hajarika was placed under suspension, white dated so-and-so. Whereas another report along with the certified copies of relevant documents have been received from the Superintendent of Police Dibrugarh, Assam white letter dated 24/7/2018 with his request for sanction order to prosecute the arrested public servant Srimati Suranjita Hajarika. Whereas as per request of SP Dibrugarh, prosecution sanction order has been accorded against Srimati Hajarika by notification. In view of the above, it is found from the copies of record that the case of Suranjita Hajarika is similar to the case of so-and-so, since she appeared in the same CCE 2014 conducted by and selected. Now the governor of so-and-so, so-and-so, so-and-so. So I think there is some orders in against her has been spelled out, my lord. At least ex officio, my lord, ex officio. So why a chance would not have been given to me, my lord? And kindly see, invocation is 19(1) and 2 of the Assam Transport Service Code. So my reading of this, it is casting a stigmatic, my lord. I am not talking about the others, but this, that's why I said one particular case I will show before this court. After arrest, my lord, what has happened after arrest? Immediately your lordship, 48 hours placed under suspension. Now, once she came from the, my lord, from custody, she was released. We made a representation before the government. It is on record. We made a representation, please invoke, because in view of Ajay Chaudhary's case, you should invoke
3
this
months.
3 months. So the government has not done anything. We file a writ petition before this honorable court, saying that this invocation has to be done in view of Ajay Chaudhary case. there is an order passed by this honorable court, you may not be discharged without following the procedure. That's what the order was passed. In the meantime, my lord, what has happened? They have discharged. In the meantime. So I think we filed an IA before the court, but court said this is a new cause of action.
No, this IA was entertained.
So this IA was, I think it was entertained in this case, my lord. Part of the record. It is entertained.
Because it was subsequent event.
But it was because it was a subsequent event. Now, my lord, similarly,
Yes.
I just judgment reserved to revision. Now, my lord will kindly see one particular Mrigan Halloi, ADO, similarly situated, my lord, is an ADO, same by Rakesh Pal, page 27, that invocation. These were very lucky. These candidates were lucky in respect of ADO. These candidates were unlucky. So, my lord kindly say you have to have luck also all this.
Yes.
So additional affidavit, kindly see, additional affidavit.
In which case?
96, my lord, 96. 96, my lord.
You are referring to Suranjita or what? Suranjita is complete.
No, my lord. I just referring an order, my lord. It's not complete, referring an order. My lord, this is 27. This is in respect of one Megan Halloi, which same footing, my lord. He was also arrested. He was arrested.
Manas Pratim. ये गलत दिया है ना?
Yes, sir, right.
Manas Pratim, no?
Yes,
That
additional
you have
affidavit.
already argued.
Yes. Additional affidavit, I want to show. This also will applicable in Suranjita also. That's what I want to show.
What do you want to read in this?
27, my lord. Page 27. When this was
It's not
arrested.
page, basically the pagination starts from 600 somewhere. Which order you are referring to?
Earlier affidavit. Earlier additional affidavit. Earlier, not now, my lord.
Second, first affidavit.
First affidavit, my lord.
देना फाइल ही दे दो. Yes.
So 28/11/2019, my lord. Yes, lordship. Page 27.
Mrigan Alloy.
Yes.
So Mrigan Alloy, who is another candidate who has not been discharged.
I don't know now, but he got reinstated. He got reinstated. Kindly see, my lord, by the order of the High Court. 8/229, this was single bench, which they said, yes, by invoking Ajay Chaudhary's case, my lord, that he was reinstated. Now, state came for an appeal at page 33. Page 33, single bench order was upheld.
Yes. We don't know finally what the fate of the man is.
Yes, but you know whether he.
This order doesn't help you any.
No, what do we want to say? Same cause of action, we have filed a writ petition, but it's the same, my lord.
That is different.
What I want to just point out, my lord. Now, my lord, Suranjita is totally.
So we can close this file, Manas Pratim.
Manas Pratim, your lordship will close it. I will not trouble anymore with those additional affidavit also. My lord, Suranjita is totally, it's a stigmatic order.
That you have read the order.
Yes, I have.
So that is a
read
distinction.
A distinction with others. If it is stigmatic, a notice was required in case of Suranjita, and they have not done in this present case.
Very well.
Suranjita is, my lord, I know, my lord, entire facts, because this is the crust of the entire matter of Suranjita. Is unlike others.
Yes.
Unlike others, my lord.
Okay.
I'll just check. Let me just check, my lord, whether I have left some point. I'll get a chance to give a reply also.
Definitely.
That is there.
We'll give you ample opportunity.
That's the point in Suranjita, my lord. Your lordship will kindly look into it. And Suranjita, I will argue, let us see what reply it comes from the other side. Only what I will take leave from this court on tomorrow and day after tomorrow, I'll be.
Otherwise also, and let's see who other counsel are there
in
the matter, the other appeals. What will happen if no one comes?
There's
so many appeals. We'll have to call out each or what? Okay. Arguments in appeals number so and so were addressed by senior advocate Mr. D. Das, who are appearing in the other matters, Mr. N. Dhar. Mr. NNB Chaudhary, you are also there. N. Dhar is there in many cases. B.D. Das. Mr. B.D. Das, yes. You will be arguing? Very well.
We adopted submission made by senior counsels, Lordship.
So you adopt the arguments already made.
Lordship.
Okay. Very well. Then Mr. A.K. Bhuyan,
Whether your lordship permission,
you can leave. You can leave.
Yes.
Very well.
I thought of remaining in this court in this matter. My top priority has to be given my.
Okay. Mr. S.D. Gupta, Mr. N. Dhar. Then Mr. S.S. Day, Mr. N.J. Katniar. R.P. Kakoti. And we'll close the opportunity then. Mr. Talukdar. Yes.
Lordship, item number 44 and 45.
Hmm.
Lordship, I am appearing on behalf of A. Somar.
Yes.
Lordship, Lordship may allow us to adopt the argument.
Oh,
And
definitely. That is, of course.
Senior advocate K. N. Chaudhary.
A note kar lena.
DK
The land
Mr.
council MS so and so appearing in appeals number so and so submits that she would be adopting the arguments advanced by senior advocate Mr. K. N. Chaudhary in the connected rate appeals. Same way, madam, who is appearing on behalf of Mr. Das in the two appeals. In one appeal only. 35.
44 and 45.
34 and 35. 34 also.
No, Lordship, only 35. 35.
Only 35. BD Das only 35. Yes. Mr.
Yes.
Yes.
My lord,
Mr.
item 42 is the senior advocate A.M. Bora IPS, my lord.
Hmm.
This matter pertains to Assam Civil Services here.
Hmm.
So we may not pray that we
Adopt the arguments. All right. Then counsel representing the appellant in item number, rate appeal number 163 has adopted the arguments advanced by senior counsel Mr. Chaudhary. Yes.
Lordship, I appear in item number 38. I am led by senior counsel Mr. I. Chaudhary. The petitioner pertains to the transport department. We also adopt the arguments.
Adopted the arguments. Note Kalena. Yes.
My lord, I appear in item 41 with regard to ACS color. And my lord, I adopt the arguments.
Same. All right. Adopted the argument. Then 44, 45, 44, 45, both done. All right. Mr. AD.
Item 43, Lordship.
43, yes.
Yes, I am also
Adopting the arguments. All right. Ms. Talukdar. SK Talukdar. You will be adopting 47 also.
No, I'm only.
Sabira Imran has already been addressed. Sabira Imran has already been addressed. All right, then Barnali Das, 42, 42, Mr. Boda was there. Then 43, ABT Haq.
Yes, Lordship, I am already.
You already adopted. Done. So we'll tick mark the appeals. Just hold on. Kamal Devnath, who was there in the first matter? Mr. Chaudhary, Mr. Patwari. Kamal Devnath was addressed by Mr. Chaudhary.
No, my lord, it's Mr. N. Dhar.
N. Dhar. Where is Mr. Dhar? He's supposed to be here. Then Mr. Borbora has already addressed. Then writ appeal 98, Pallavi Sharma. Mr. Mishra. वो अलग से अटेंडेंस सबका मार्क कर देना कौन कौन किसके केन चौधरी सबका नाम आया हुआ then 28 call Mr. Dhar, otherwise we'll say no one has appeared to address the court. And there is there in 30 also, 31, 32 and 34 Mr. A. Talukdar. 34 no one has come. All right, note that no one has appeared to address the court. Then 37 also, no one has come. 38, you have adopted the arguments, 38. No one has come.
53, no?
Ms. Talukdar has adopted. Then 42 adopted arguments. Make the statement of Mr. Patwari. ABT Haq adopted arguments. 44, Madam. (46). No one has come. ये तो डी चौधरी साहब का नाम लगा रहा है. Call Mr. T. Chakravarti, D. Chaudhary, P. Datta. They have to be here. Then 47 adopted. Or Mr. Chaudhary had already argued. Sabira Imran, Mr. D.K. Mishra had argued. No? Yes. F. Khan 48. All right, what do is record this. No one has appeared to argue the matters in appeal them or so and so. List tomorrow. It is made clear that in case the counsel representing the appellants do not appear, this court shall be compelled to proceed with the appeals ex parte. Then 49.
Lordship. Lordship, I have set up the arguments of Honorable Mr. Ken Chaudhary and Mr. Didas, sir.
Okay.
The faulty process of investigation has been done.
Yes, yes. Okay, okay. Then comes again for 50. 50, no one is there. 51.
Lordship, I'll adopt 53, like NNB Chaudhary, 51, 52, and 53, and the rest of the submissions of the learned senior counsel will also be adopted.
Adopted arguments. Mark his attendance. 54.
I am 53, my lord.
You are 53.
Yes, my lord.
You want to say
Yes,
anything?
I want to say something, my lord.
All right.
Most of the part I adopted, my lord. Some part, my lord. More thing is that, my lord, your lordship kindly go through the. Earlier, your lordship will complete the list.
All right, let's complete the list.
Yes, my lord.
54, no one is there. 55. H. Gupta. 56, KP Patak, Khatni RG. 57, 56, 57.
Lordship for 57, 58, 59, 60, 64 and 65, your lordship. I am adopting, your lordship.
Mr. S. A. Hussain.
Lordship.
60, 57 to 60 and
64 and 65.
All right.
Lordship.
Okay. Then comes 62.
My lord, 62, my lord.
Mr. Ken Chaudhary.
Only difference is, my lord, is in the writ petition stage, this was the writ petition where all the provision extension orders of APS were sent. And the learned senior without adhering to that, my lord, simply dismissed.
All the
provision extension of Assam Police Service officials, which was challenged in this writ petition.
Okay.
And my lord, the learned senior without discussing anything, simply dismissed it.
Now give it a brief note.
My lord.
Then 63 also. 60, Ms. Patwari. 63 also. It's your matter.
63, my lord, just now.
All right, just now, Mr. Das argued. D. Das. Okay, 64, 65 done. Then 66, Mr. A. Jain. Manas Pratim, D. Das has argued. Mr. Das has argued. Then 67, Deepak Khanikar, H. Ahmed, none appears. 68, PJ Saikia. NA, none appears. Then 69, Mr. Chaudhary has addressed. Okay, so mark the attendance accordingly. The order sheet will be such. Arguments in appeal number so and so have been addressed by. Yes, Ms. Gupta. What do you have to say? You've got a few appeals here.
I am not there. Madam.
You're not there. Very well. Then we'll just say no one appears. We are spilling over the matters tomorrow. If anyone comes, well and good. Otherwise, we'll close the arguments. In appeals number so and so, no one has appeared to represent the appellates. However, in the interest of justice, the matters are being re-notified on Thursday, so that in case any of the counsel representing these appellants is desirous to address the court, the arguments can be advanced, failing which the right to make submissions will be closed. This observation is being made in view of the fact that the appeals have been regularly heard over a period of last week, and all concerned counsel are aware of the proceeding hearings, continued hearings. Next, 61, Mr. PK Munir. You already said?
He is out of station. On behalf of him, Lordship, he informed me that adopting his.
Adopting.
Lordship.
Okay, next. Yeah, इसको ये कर सकते हैं ना. Matters be posted on Tuesday next. On that day, if any of the absent counsels is desirous to address the court, permission shall be granted. However, if no one appears to argue the matters, वो फिर बाद में लिखाई दिया आपका, ठीक है ना? And on that day, submissions on behalf of the respondents will be heard. Yes.
Yes, my lord, most of the part, my lord, what argued by my all of my senior, my lord, I have adopted, my lord. I was shown your lordship 2-3 points, my lord.
Yes.
Your lordship kindly come to the page 739. In that judgment part, my lord has stated, we made statement before the police that we have given, my lord, bribe money to the, my lord, Rakesh Pal, my lord. And by this we are committing the alleged offense, my lord. But if your lordship go to the, my lord, charge sheet part, my lord, that is not available. And our 161 statement was not recorded, my lord. Your lordship kindly go to the page 739, my lord. Para, my lord, 44. That I am reading, my lord.
Para 44.
Yes, my lord. Para 44, my lord. Bottom part. Without entering into any legal argument as admissibility, which is for the appropriate fora to decide, the office files also contain statement made by a section of the petitioner before the police, admitting to their complicity in the legal activity to which they were beneficiary. The statement of such found in the office file are that of Rituras Gogoi, so my name is mentioned, my lord. I was Dipsika Spukon. He was A52, accused number. Ganesh Chandra Das, he was accused number 58, my lord. And Monica Terangvi, my lord, he is the accused number 48, my lord. In 207, my lord, when document has been served to us.
Obviously, confession made before a police officer cannot form a part of the charge sheet. So
Yes,
what is so peculiar about it?
Because this has been taken.
Yes, for a discharge.
Yes, my lord.
So for a discharge, this could have been referred to. Nothing wrong.
But discharge they have taken this part, my lord. But if your lordship go to the, my lord, charge sheet part, my lord, that is not available, my lord.
Mr. Chaudhary,
yes, my lord.
You're a seasoned lawyer practicing on the criminal side.
Yes, my lord.
Whether confessional statement of the accused made to a police officer can form a part of the charge sheet, then you get your own.
And many judgment is
so
there.
then you get your own answer.
Yes,
it will not be a part of charge sheet. Never it will be.
Yes,
But
sir.
yes, part of the investigation file it will be.
Yes, ma'am.
And that is what has been looked into. What is wrong in it?
My humble submission, our statement has not been recorded at any point of time, and that was taken the foundation by the learned, learned single judge. To my lord, discharging this.
So we will check the record. Your statement is there or not?
Not recorded, my lord. Our
Learned single judge has taken note of those statements.
Criminal record.
in that criminal record, that is not available, my lord.
So, Mr. Chaudhary, now this is the third time we are telling you
Yes, sir.
why it will be a part of the charge sheet. It can't be. What is the purpose? It can't be proved.
Yes, my lord.
Then-
It can't be, my lord, part of this hardship, my lord. Your
Yes.
lordship is absolutely correct, my lord.
Then
Nowadays, my lord, after the judgment of my lord Monu Sabha and others, all the document has been given to the, my lord, accused person, my lord. In this case also, my lord, some statement of the accused person has been given under
that is a
207.
futile exercise. It
Yes, sir.
can't be used for any purpose
Any purpose, my lord.
in the trial.
Yes, my lord.
But yes, for this purpose, yes,
Yes, my lord.
it was relevant.
I want to submit before your lord, that statement is not available, my lord. In the
So
record, my lord.
your case is, there is no such statement.
No such statement, my lord. And I know, my lord, what statement I have given. My statement was not recorded at any point of time. That is my argument, my lord. I am not
Okay.
going to the other part of in charge sheet part, my allegation against me, my lord, is page number, my lord, 16.3, para 16.158. I am not reading, my lord. And for it, that is for Monica Rohang P, Terang P, my lord. Para 16.7 in page number 162, Dipsika Fukan, my lord. And para 16.13, 169 for Ganesh Chandra Das, my lord.
What are you referring?
It is, my lord, in the volume 1, my lord, from the charge sheet I am
So
referring.
what do you want to read up from that?
I want to show your lordship that I am going to read that in that statement, in the charge sheet, nowhere stated, I admitted before the police that that is my submission. Because I am arguing
Yeah,
for
the same circular route you are taking.
Yes, my lord. I am arguing.
Why they would mention it that they have confessed? They were not required to, because they can't prove that confession
Yes,
in the criminal trial.
I am appreciate your lordship, my lord. But
Thank
thing
you.
is that, my lord.
We are obliged.
Yes, my lord. But thing is that, my lord, that has been taken by the single judge in the judgment.
Yes,
Yes.
that is a part of the decision-making process
Yes.
considered to be a motive for the decision.
Yes, my lord.
So what is wrong in it?
That is the motive, my lord.
So we will see. We just now, as per your direction, we are required to verify whether the statement is there in the record or not. That's all.
Yes, my
We'll do
lord.
that.
Yes, my lord.
Okay.
Yes, my lord.
So if the statement is there,
Yes, my lord.
your fate is closed.
Yes, my lord.
Okay.
Yes, my lord. I am arguing before your lordship is that, my lord, they have given all the document which has been relying by the prosecution and not relying by the prosecution. That is why
We are
could
not considering a
Yes, my
criminal
lord.
trial or a criminal.
Yes, my lord. And I know, my lord, my statement was not recorded at any point.
All right.
The first point is that.
Where is your pleading? Where
My
is your pleading that your statement was never recorded? Read your
Statement
pleading.
not recorded, my lord. That pleading is, your lordship, I will come later, my lord. Now,
No, you have to answer right now.
Yes, my lord.
You are arguing without a pleading, then we'll not even
My lord.
entertain such an argument.
Just a minute, my lord. Paper paste দেখা যাচ্ছে না, রাত্রিবাজে পড়ছিল। Then, my lord, I will come later on, my lord. I shall the second point, my lord. One important point is that, my lord, there are two, my lord, other person, my lord, Vilisha Borua, approver, and Sanjana Fukan, my lord. Your lordship kindly go to their suspension order, my lord. It was on page 216, my lord. What is statement? 216, my lord.
Yes.
Have you also got it? I am coming to the last paragraph, my lord.
Yeah.
The governor of
216 in which file?
216 of
41.
Rito bill, my lord, 47, my lord. Item number 53, my lord.
Yes.
Yes, my lord. Your lordship kindly come to the, my lord, third paragraph. The governor of Assam therefore is pleased to withdraw the service of Obhisika Borua from Revenue and Disaster Management and pending initiation of departmental proceeding placed for under suspension sub-rule 1, rule 6 of Assam Service and Discipline Rule 1964 has been followed.
Yes.
In respect of him and Sanjana Fukan, same, my lord, they followed the Assam Service Discipline and Appeal Rule. Whereas in my case, my lord,
They have not been discharged from service. That is why. They have not been discharged from service.
Yes, my lord.
So they
Yes,
had to
ma'am.
follow the rules. What else was could
In
be done?
respect, first, when we were suspended, my lord, that rule has been followed. Subsequently, it was not, my lord, followed at the discharge of the rule. My humble submission before your lordship is that it is the foundation of the police report, my lord. On the basis of foundation of
That
the police
argument is a
report-
different argument.
Yes, my lord.
Yes,
Foundation of
okay.
the police report, my lord, I was discharged from my service, my lord.
Yes.
If it is the foundation, my lord, then definitely, my lord, I am entitled to protection under Rule 9 or some disciplinary and service rule and
Okay.
311(2) of the Constitution of India, my lord. That
Yes.
was not given to me, my lord.
All right.
And my lord,
Page 29 of-
and my lord, last,
Yeah, yeah,
that is my submission, my lord. And your
Okay.
lordship kindly come to the page 29, my lord. Your lordship asked that whether pleading is available, my lord. Page 29, para 4 of the, my lord, volume 1. I am reading, my lord, slowly. For that, page 29. For
This is
that,
in writ appeal.
yes, my lord.
Where is this pleading in the writ petition?
My lord, at that time, we are not receiving the copy. That is why at the time of filing writ appeal, we take this
Yes,
point, my lord.
we understand. Yes. Read para 20.
Page 29, para
Yes.
4.
Yes.
For that, Honorable Single Judge, while appreciating the original office file containing the noting regarding the decision-making process, failed to compare the same allegation level against the appellant in their respective charge sheet filed in person of police investigation,
All right.
which is evidently placed.
Yes,
as-
we have seen appellants categorically deny making such self-incriminating statements before the police.
Yes, my
All
lord.
right.
Yes,
We have, what is their answer?
My lord, government, my lord.
Yes.
Government has not given any answer.
Not effective file count.
In this case, affidavit has not been filed by the government.
This is Kunal Das.
No, my lord. Ganesh Chandra Das.
All right. Mr. Roy, take note of this submission. There is a pertinent pleading that their statements were never recorded.
Yes,
And
my
you have not controverted that submission.
Yes, yes, ma'am.
All right, take note of that submission. Okay,
Yes.
Yes,
very well.
Yes, my lord. And one important thing, my lord, just now I came out, my lord, you can have although it is not a part of pleading, my lord, but very important thing, my lord. Duta reason. এটো FSL report, no? বই কেইখনো দিবি হা। Your lordship, Ganesh Das today.
What are you trying to point out?
Yes, my lord. I want to say, my lord, in FSL report, my lord, it is categorically stated so far relating to Ganesh Das and Deepsika Fukan is concerned. For Deepsika Fukan, 2 answer script and Ganesh Das 3 answer script, my lord. Nowhere it is stated it was tempered, my lord. Either there is a specific.
You to take a ground. These are writ petitions.
Yes, my lord, but
Yeah, there is
I
no
was
such
not
argument.
present. That is my lord.
If there is no such argument, then we can't.
Yes, my lord.
Reading, then we
I
can't.
want to take 2 judgment, my lord, to your lordship, my lord.
Yes.
That if necessary, my lord, I can take it by filing additional affidavit also. my
Not
lord.
now. Now
Yes,
we
sir.
are in the
Yes, my lord.
almost on the cusp of closing the hearings.
Just now when my lord, Lanet Sinophe and Mr. D. Das argued, my lord, I
Yes.
verify it and came it to me, my lord.
Yes.
And your lordship kindly come to the, my lord, judgment. 2009, 2 SSC, my lord. Rup Singh 570, my lord. I have given the book list also, my lord. Rup Singh Negi versus Punjab National Bank, my lord.
Yes.
I am relying paragraph 14, 15, and 23, my lord, where it is categorically stated that the purported, my lord, evidence collected during the police investigation, my lord, against the accused, my lord, cannot be the evidence of the disciplinary proceedings.
These are not disciplinary proceedings.
Yes, my lord.
Why this judgment is being cited?
And another one is another judgment, my lord. 2015, 15 SSC 151, my lord. Ratnesh Kumar Sudhuri, my lord. That is, my lord, para 3 is the facts, 17 and 27.
What is the principle of law?
Yet, my lord, he was actually appointed as a, my lord, physiotherapist, my lord. And a post has been advertised for sex therapist, my lord. And subsequently, he was, my lord, terminated from the service without any inquiry, my lord. And on the basis of vigilance report, my lord.
Yes, yes.
And my lord, and finding, your lordship will find, my lord, era 27, my lord,
Yes.
of that judgment, my lord. That is my humble submission before your lordship, my lord. This is 27, my lord. May I read or my lord, your lordship will read?
Yeah, as your choice.
Yes, my lord, I am reading, my lord.
Yes.
And my lord, earlier 26 Pulong Modi case has been discussed, my lord. I am not reading. In the case in here, it is clear crystal that para 27, my lord, page 166. It is in the case at hand, it is clear, as crystal clear that on the basis of complaint made by a member of legislature, an inquiry was directed to be held. It is innocuously stated that complainant was relating to illegal selection on the ground that
This was a case wherein inquiry was commenced.
Yes.
That is what the observation is.
behind the back of the, my lord.
But inquiry was commenced and then they took the decision
Yes, my lord.
behind the back.
And overall, so all has argued, my lord. The thing is that, my lord, here is the foundation is that the police report, my lord.
Yes.
And on the basis of police report, my lord, we are, my lord, all are terminated from their service. So, my lord, we have a right to, my lord, have a notice in this case. Because law of the land, Manaka Gandhi or losses nominated, nobody should be condemned unheard, my lord. That is my submission before the.
Single judge foundational police.
Yes, my lord. In paragraph 47 of the judgment of the learned single judge has said that police report is the foundation of this case.
Yes.
If that is so, my lord, then notice is necessary, my lord. That was
Yes.
not done in the instant case.
Okay.
And there is a stigmatic view has been taken, my lord. It is not that, my lord, it is a, my lord, termination simpliciter. That is my humble submission before your
Very
lordship,
well,
my
very
lord.
well.
I have other judgment, but not necessary, my lord. Let me
Thank you for relieving us so early, so quickly. Thank you. Yes. Yes, madam.
Lordship, I'm very sorry, Lordship, in item number 35 and 37, when it was called for, I was not there, Lordship.
Yes.
And my respectful submission is this, Lordship. We are adopting the argument of Learned Counsel, DK Mishra sir and Ken Chaudhary sir.
Okay.
35 and 37.
35 and 37. Okay.
Obliged, Lordship.
Yes.
My lord, so for item number 23 and 68, my lord, I am appearing in this case.
Yes. 23.
23 and 68, my lord.
Yes.
Of today's list, my lord. My lord, the already full-fledged hearing is, my lord, completed by this court, my lord. And nothing, no point is remain to be, my lord, argued. And my case is also covered by the arguments already made, my lord.
Very well, very well.
My lord, there is nothing to me, my lord, submit again, my lord.
Very well.
That's
Thank you.
all, my lord.
Okay.
23 and 68.
Anyone else from the absentee lawyers? All right. Thank you. Record that lottery sheet. Tuesday. Tuesday.